Big poppin', money in the bank, coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me big poppin'. Money in the bank, coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me what to tap it.
What's poppin', everybody? I guess you could say that this is a late night pour up with your girl, that girl, Henny, your favorite goss and doc tender. And tonight, we're going to be pulling an all-nighter because as y'all can tell from the thumbnail and the title of the video, we are reading Karmelo Anthony's motion for a new trial. All right, so we are about to get all up into all of these good docs. But first, if you are new here, welcome. Please be sure to like, comment, and of course, subscribe. Click that notification bell, select all so that you get notified whenever I do a video. Now, I want to go ahead and I want to start off by letting y'all all know that, yes, Karmelo Anthony's new... Oh, did y'all see that? Y'all weren't supposed to see that. New trial. Karmelo... Wait a minute. Hold on. How did we get there? I guess because it's Google. Karmelo Anthony's new attorneys have filed 2 motions today. So let me take this down and let me put the motion up that they filed earlier today because I did not get a chance to post that video over on IG and I know that y'all need to know what is going on. So the motion for to recuse was put in today, okay? The motion for the new trial was also put in today as well. That is right here on these documents. If you can see where I am doing my square at, that is where it was filed at. So they want to remove Judge Roach from this case. And I don't blame them because Judge Roach would be considered to be fruit of the same poisonous tree, which they don't want him there. Okay, he did not handle this case very well. Everyone knows that. Even if you weren't really keeping up with the trial on a day-to-day basis, you definitely know that he dropped the ball on this case and the fix was in. Let's just call the spades and the things. Oh, I can't see y'all comments on. Oh, I didn't put it on the stage. Duh. There y'all go. So with the motion for a new trial, of course, that means that Karmelo Anthony's team had to file. And so we have the filing, you guys. So let's get into it and let's not waste no time because we have 193 pages to go through. Now, if you were with me over on IG, then you know that I had already started reading some of this to you. So we're going to start from the top because we can't just start from the middle here, being that we're on YouTube and we need to have a complete record and document of it all. So please be sure that you are leaning on that like button, share this out, and let everybody know that Henny is reading the court docs, baby. All right. I wasn't going to do this. I wasn't going to do this tonight. Give me a second. I wasn't going to do this tonight. I was going to actually wait until the morning. But I decided to come live tonight and just get it over with because we started reading on IG. So without further ado, let's get into the court docs. Y'all ready? Moderators, please be on the lookout. Please be on the lookout for any trolls. And get them out expeditiously. If you see anyone trying to push the live to go in a different direction, please, again, get them out expeditiously because tonight I'm not with the foolery. I'm not with the uckery at all. We're going to stay on task tonight. Okay? All right. I'm trying to get my post up while I'm talking to y'all so that people can know that we live, but I'm not able to get these posts up the way that I want to. And it's okay. So before I lose anybody's attention, because again, this is going to be a long one, let me go ahead. And as long as I got it in the story post, I should be okay. Hold on one second. All right. And I'm just going to share that to the story post. Boom. All right. So it says, defendant's motion for a new trial, as you can see, state of Texas versus Karmelo Sincere Anthony. And how you know that these are true documents, because if you look up here in the top corner, that is the stamp from the clerk. So that's how you know that it's real. All right. So the defendant's motion for a new trial and brief in support to the honorable judge of said court come now, defendant Karmelo Anthony, by and through the undersigned counsel and pursuant to rules 21.1 and 21.9 of the Texas Rules of Appellate Procedures, moves the court to set aside the judgment of conviction and sentence and grant a new trial. The defendant moves for a new trial on 4 grounds. First, the court committed structural error when it materially restricted public access in violation of the right to a public trial, which is true because up until they did their jury selection, they had people of the court in there. Hey, oh shoot, Big Gene is up in the building. I feel so special. Hey, Big Gene. So if you paid attention to anybody that was reporting from the courthouse, you know that after the voir dire was done and they selected the jury, the overflow rooms were no more. And even when they went into the overflow rooms, there was no audio, there was no visual. It was just a room that they sat them in to kind of pacify them. So this was not a true public trial. Second, the state's reputation of the parties' unrecorded evidentiary agreement after the defense relied on it coerced the waiver of Mr. Anthony's right to testify and denied him a complete defense. So they had an agreement between the defense and the prosecution that was not recorded. And the defense was relying on that agreement. But when the prosecution backed out, because that's what they're not saying in so many words, they're not saying the prosecution backed out, but the prosecution backed out. And because of that, Karmelo did not take the stand. So for everybody who was wondering why Karmelo did not take the stand, this is why. Because they backed out, the prosecution backed out of whatever agreement they had off the record. And so his attorneys go on to say that this was in violation of his constitutional rights. Okay. The third, the trial court improperly instructed the jury on the applicable law. Now, I know when I heard, I can't exactly remember what was said that was told to the jury. But I remember when they were telling us what the jury instructions were, the people who were reporting from outside of the courthouse, when they were giving us those jury instructions, I was listening and I said, well, those instructions seem like they just backed the jury into giving just assigning it as murder. Like it didn't really give the wiggle room for manslaughter like that. It was like either you find it as self-defense or you find it as murder. And of course, without him taking his side, telling his side of the story and taking a stand, that just left whatever the prosecution said. And we all know how that went, right? And the fourth reason is the cumulative effect of these errors warrant a new trial. So together, all of these things, these 3 reasons that they gave, together, they warrant the reasons for a new trial in the interest of justice. They want this new trial. And we all have been crying out as the public saying, this boy needs a new trial because he was railroaded. There's no getting around it. So now we get into the introduction of the case, right? And this case presents a structural public trial violation. Okay? Because the trial was supposed to be a public trial. And it was not. There were no cameras. There was no audio. All you had was CBS giving us kind of their version of a transcript, which people were taking to be the actual transcript, but it was not. It was not a public trial. You did not have an overflow room for the public to get into or any of that. So it was not a true public trial. Okay? Diddy's trial was a true public trial. Even though they did not have cameras or audio in the courtroom, they had someone in there that was inner city press who was giving their version of transcript on Twitter. And then they had overflow rooms. And at one point in time, they had about 5 overflow rooms opened at one time, making sure that people were able to watch and hear the trial, even if they weren't able to get into that main courtroom. Now, that is a true public trial. Okay, so it goes on to say that the court had authority to manage courtroom security, decorum, and capacity. But it adopted an administrative restriction that foreseeably excluded members of the public from a high-profile criminal case. It was required to make recorded supported findings and to consider reasonable alternatives to closure. The court did neither. The access regimen limited public attendance to a narrow daily admission process, a small number of seats, and no continuing overflow or audio or video access after jury selection. Because that closure affected the trial proceedings themselves, and for the 3 additional grounds set out in this motion, the defendant asked the court to set aside the judgment and grant a new trial in support. The defendant shows the following. So they go on basically to say that because of the reasons we gave above, those 4 reasons that we just gave you, this is an additional reason why we feel he needs a new trial. Okay. So it gets into the factual background with the case and the verdict. All right. So it says the case arises from an altercation at a high school track meet. The defendant, Karmelo Anthony, was charged by indictment with the murder of Austin Metcalf, alleged to have been committed on or about April 2nd, 2025 in Collin County, Texas. The defendant pled not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. The court's charge submitted the offense of murder. The lesser included offense of manslaughter and the law of self-defense, including the justified use of deadly force. The defendant did not testify. On June 9, 2026, the jury found the defendant guilty of murder and the court imposed a sentence of 35 years confinement. These matters appear from the indictment, the court's written charge, and the judgment. The court drew national attention from the onset, and the court appointed a public information officer to assist with media credentialing, communications, and access logistics. In practice, public and media access were administered through that process. What follows is how that access was in fact administered before trial, at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. Okay? So it goes on to be, right? Secrecy before the trial, the gag order, chamber conferences, and no public pre-trial hearing. All right. The closing of this prosecution to public view began more than 10 months before the trial. On July 28, 2025, acting sua sponte, and on a no-party motion, the court entered a order prohibiting extrajudicial statements, a gag order, binding the parties, their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court-appointed officials, which by its terms remained in force through the trial. So this is where they're talking about everybody being underneath the gag order, which we already knew everyone was under a gag order. Okay, so as soon as the trial was over and they lifted it, that's when we got that horrible, disgusting interview that Jeff Metcalf did with Sarah Fields. Okay, don't even get me started on her. Do not get me started. Okay, covered persons with firsthand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. So even if they wanted to, let's say that I had reached out to one of the attorneys and I wanted to talk to them, like, well, what is your strategy going in? They would have to write the court and get permission to be able to discuss anything. All right. The gag order's terms were sweeping unless first approved in writing by the court. No covered person could make any extrajudicial statements that addresses the character, credibility, expected testimony, guilt or innocence of any party or witness, that discusses evidence anticipated to be introduced at trial, or that intends or is likely to influence public opinion or potential jurors. Restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt fines, attorney discipline, and other remedies. So it doesn't matter who you were, whether you were legacy media, whether you were an independent journalist, a blogger, they don't care. If you were close to this case and you went outside and you was talking about anything, you were going to get fined, or you were going to get in some type of trouble, disciplinary actions, whatever the remedy be. The judge would be the one that would have to define that. Its findings were three sentences that media coverage, quote, has the potential to cause imminent and irreparable harm to the defendant's rights to a fair trial, unquote. That alternative measures, venue change, jury screening, sequestration would be inadequate alone. Now, here's the thing. Let me put my thing there so I understand. I don't understand how this jury was never sequestered. I really don't. I don't understand how the jury was not sequestered. This is considered to be a high profile case. Okay. And it is what it is. I just feel the same way that I feel when it comes down to why Diddy's jury was not sequestered. So, irreparable harm. All right. Fair trial, that alternative measures. And I don't understand how a change of venue was going to harm his case. Someone please let me know how that would have changed that wouldn't have gave him a fair trial. And that narrowly applied speech restrictions are necessary to protect jury impartiality. No evidence is recited. Okay. So there's no evidence that says that if anyone were speaking, that it would taint anything. All right. The order permitted only procedural announcements, hearing schedules, court filings, and statements required by legal or ethical duty. A safe harbor that presupposed filings the public could see. So they could only talk about things that we were going to be able to see and pull from the courthouse. Where we pull the court docs from. By its terms, it would yield only to further written order of this court, and the amended order later reaffirmed it until the completion of the trial. In the 10 months it operated, no person was ever alleged to have violated it. So as far as the public records reflect. So nobody violated the order. Okay, nobody violated the order. The substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conference with the court, including May 21st, 2026 conference in chambers, at which the parties' evidentiary understanding was described to the court, and on May 29, 2026 meeting addressed trial security scheduling. So they discussed this agreement in the judge's chambers on May 21st of 2026. Go figure. So now that leaves me to have a question. Ooh, me, I have a question. Ooh, me. So if the judge knew about this, oh, wait a minute now. Hold up. Wait. Because I don't know if who y'all was watching or if y'all was paying attention, watching anybody that was covering this trial. But do y'all remember on the day that they closed the case, like they said that they was no longer going to be, that the defense rested their case? You want to know what I'm wondering? If the judge knew about this, then why would he allow the defense to shut this case down so quickly? That's what I want to know. Because if you remember, people who were there at the courthouse, they all reported that they went out to lunch. The defense had started, this was the first day that the defense had started putting on their side of the case. The defense presented a couple of people and then they went to lunch. And their excuse was, once they started calling their witnesses to the stand, they didn't want any interruptions. So they didn't want to stop for, they didn't want to have to stop for breaks. They didn't want to have to stop for none of that. So when they were supposed to go back in, it was said that, oh, we're not able to go in because something is going on. And I remember, I believe it may have been Neek. Hold on. I'm sorry, y'all, I'm typing. So it may have been Neek who said that when they were finally able to get back into the courtroom, that the families were both in the courtroom. Both attorneys were in the courtroom. Karmelo was in the courtroom and the judge was in the courtroom. But the jury was not there. So I'm wondering what was said in that courtroom. All right, let's continue. The substantive pretrial work of the case was then conducted out of the public view. The parties' pretrial conference with the court, including, I read this already, but I want to read it again, including a May 21st, 2026 conference in chamber at which the parties' evidentiary understanding was described to the court. And on May 29th, 2026, meeting addressed trial security and scheduling occurred in chambers outside open court. So they discussed their security and scheduling in the chambers. All of this stuff is happening inside of the chambers. All right. No reporter's record of them exists. A matter the hearing will confirm. No pretrial hearing was ever held at the access restrictions, and the register of action reflects no such setting. The public docket disclosed no motion in limine and none of the substantive pretrial litigation that in fact occurred. Filings that were hand-delivered rather than filed in the district clerk public office. Whoa. So what they're saying is y'all had this private meeting where y'all came up with this understanding that was not documented by anyone. It was not done in the public court where the people could see and hear what y'all was agreeing to. Y'all was discussing security measures and scheduling, and this was all done inside of chambers, not in the public courtroom where it could be documented. It also is saying the biggest takeaway for me right now is that public dockets disclose no motions, and it's saying filings were hand delivered and were not filed through the district clerk's public record. Say what now? Come again. So y'all are filing paperwork without actually running it through the proper channels and hand delivering this stuff. This is unheard of. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. So, with that being said, and that's true, because every piece of paper that goes through to the court has to be submitted through the clerk. And they have to have something in place for them to be able to seal those records before they even go into file. Because let me tell you how sometimes we able to get these filings and other people can't get them sometimes. Like you see how content creators, they'll go to get the file and others will come back and be like, oh, I couldn't get nothing because they were sealed. If they put the paperwork through first and then request for it to be sealed, it's open to the public until they seal it. So instead of saying we're going to order the record sealed until the trial's conclusion, they were just skipping the county clerk and handing it to each other. Ain't that about a bitch? And so hearings and things that were going on were not even on record. So all of these meetings in chambers were happening basically off the public record. What the hell was that? Why was that open? Hold on, y'all. I don't know what that is, so I'm not even gonna bother. Okay. Let's carry on. On May 18th, 2026, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum entered to govern all aspects of the trial proceeding. The order recited the directive of Waller versus Georgia and Shepard versus Maxwell, found that unrestricted access and activity may compromise courtroom security, juror privacy, and the defendant's right for a fair trial, and promised reasonable public access consistent with constitutional requirements. And then they cite Exhibit 1. Now, we already here, so we might as well just go ahead and do it. So let me go ahead and let me open this document up in a separate window. So when they say things like Exhibit 1, Exhibit 2, we can just go ahead and shoot over to the exhibit. So I'm going to scroll all the way down to the exhibit so that we can see what they're talking about when they start talking about Exhibit 1. Yes, super corrupt. Whole trial was a mess. Whole trial was a shit show. All right. So they said Exhibit 1. So here we have Exhibit 1, the amended order regulating trial proceedings that they just spoke of. So here it is right here. The amended order regulating trial proceedings, media access, security, and courtroom decorum. It says, on this day, the court enters this order to govern all aspects of trial proceedings in this manner due to the significant public and media interest in the case. The court finds the specific procedure necessary to ensure defendants' right to a fair and impartial trial, the orderly administration of justice, the safety and security of all participants, and reasonable public access consistent with constitutional requirements. The court has considered the directives set forth in Waller versus Georgia and Shepard versus Maxwell, as well as all applicable constitutional provisions, statutes, and case laws. The court finds that these cases, as generated substantial public and media attention, and that unrestricted access or activity may compromise courtroom security, jury privacy, and the defendant's right to a fair trial. The court further finds that the reasonable time, place, and manner restrictions are necessary and appropriate, and that while the media and public retain the right to attend proceedings, such access is subject to the limitations set forth in this order. The courtroom shall open each day of trial at 8:30 a.m. Entry shall be permitted beginning at 8:30 a.m. Now let's stop right there, because a lot of people who were down there covering this trial said that the court was supposed to be open at 8:30 to them, but people were getting there at 6:30 in the morning. Okay? And they were being allowed to line up way before the permitted time. And every day, specific people were allowed in the courtroom first. Yeah. Y'all thought we forgot. Anyway, for members of the media. So members of the media were supposed to be allowed to go in at 8:30 and at 8:40 for designated family members and 8:50 for members of the general public. So media was supposed to go in before the family. The family was supposed to go in before the public. So you figure that by 9 o'clock, everyone should be inside, right? But that's not what was going down, because members of the Metcalf family were being allowed to go in with and before media. Go figure. And if this is how this was supposed to be, there should have been 3 separate lines. Let me tell you something. Outside that Diddy trial, you had the general public line and you had the media line. That's how that went. It was 2 separate lines. So if y'all have 3 different access times, then y'all should have had 3 lines outside. Anyway, no more than 9 members of the media shall be permitted in the courtroom at any time. Only 9 media members. Seating shall be on a space available basis. The courtroom doors shall close promptly at 9 a.m. and individuals arriving after that time shall not be admitted until a recess. Once admitted into the courtroom, no person shall leave and re-enter during proceedings except during recess. So that means if you were sitting in there and they were testifying and you had to go to the restroom, once you walked outside of that door, you were not allowed back in. And I just want to remind everybody that when Mel came up here and Mel was talking about what happened with Karmelo's mom, because, you know, Jeffrey, because we're going to call him Jeffrey over here, Metcalf was saying she wasn't in there when they sentenced Karmelo. If you remember, Mel told us that the mother was there because she had to give an impact statement for him, right? A character, what is that called? It was a character witness. She had to speak for her son before the sentencing happened. So obviously she was inside of the courtroom. Mel said she was accidentally, which I believe was purposefully and strategically, escorted outside of the courtroom. And once you left, you could not come back in. So while they were over there on Sarah Field's page lying, saying that people were spinning narratives and lying about that, it says it right here in black and white that no person shall leave and re-enter during proceedings except during a recess. So if she got accidentally ushered out, which I believe was accidentally on purpose, she wasn't going to be allowed back in. It doesn't matter. Okay? The determination of who qualifies as a member of media, which media representatives will be permitted access to the courtroom, and the allocation of media seating shall be made with representatives. Shall be made with the assistance of court-appointed public information officers for the court. Media representatives must comply with all credentialing requirements established by that officer. The court will not intervene in or resolve disputes amongst members of the media regarding access or seating. So this is Exhibit 1. No person, including members of the media, shall photograph, record, or otherwise visually capture the image of any witness, prospective witness, juror, or prospective juror, nor shall any person publish or disclose the name, identity, or personal information of any witness who is a minor, juror, or prospective juror. No person shall communicate or attempt to communicate with any witnesses, prospective witnesses, jurors, or prospective jurors prior to the return of a final verdict. No interviews of witnesses, jurors, or prospective jurors shall occur until after the conclusion of the trial and only if voluntarily agreed to by the person. Photography, video recording, audio recording, live streaming, or any other form of recording or transmission of the court proceeding is strictly prohibited. No cell phone or other electronic devices will be permitted into the courtroom. Electronic devices may be permitted in the courtroom by the media for note-taking purposes only. Okay? And they're subject to approval by the court and must remain silent at all times. No media interviews shall be conducted in the courtroom, in the hallway, or any security restricted areas of the courthouse. All interviews must take place only in designated areas approved by the court. So I guess we get an idea, because I don't feel like we really need to read much more of this. I will also be posting some of this information for y'all over on my Instagram page. So let's get back into the court doc and get back to what we were reading, because this is a whole lot of reading. I told y'all, we're going to be here for a long time. Did they really think no one would find out the illegal things they were doing? Here's the thing. I don't think that they expected that Karmelo Anthony would be able to request for a new trial, let alone have six seasoned vets at this take on his case pro bono. I think they thought they had this in the bag. All right, so now let's get back into this. Defendant's motion for new trial and brief in support. Its operative terms were these. The courtroom would open at 8:30 a.m. for the media. Oh, we've already read this. So they basically broke down what we just read. They broke all of this down. Okay? So let's see what they had to say about this. The order also closed the courthouse grounds themselves, which is true. It placed the entire courthouse campus, including the parking lot, sidewalks, green space, and any other designated area, under a nightly curfew of 11 p.m. to 6 a.m., beginning May 31st, 2026. It designated restricted zones on an attached exterior map. And it ordered the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during the trial. Under the order's enforcement clause, any violation, including a citizen's presence in a courthouse parking lot or on the green space besides the courthouse before 6 a.m., exposed the violator to immediate removal from the courtroom, courthouse, or court grounds, and the imposition of sanctions, including contempt of court, and no warning is required for enforcement finding of any kind accompanied the curfew. All right, so that's what we were looking at before we moved away from here. They were showing us the restricted perimeters. All right, so this is the courthouse right here, and what they're saying is no one was allowed to be in any of these red areas. All right. Let me see if I could turn this. Does this give me the option to turn it? It doesn't. Okay. So basically the red areas are restricted security areas, which are designated for control of the courthouse. The yellow is the primary ingress and active traffic areas. So here's the active traffic areas in blue. This is a restricted space. This is a restricted space. Now, somebody please explain to me, because this looks like the highway. How are these two spaces way over here restricted and the courthouse is all the way over here? All of this, you can't be anywhere in here, nowhere around anywhere where it's red. This is the courthouse. The courthouse sits in the middle. Here is the parking lot, okay? You could not be anywhere in these areas at all. So remember, they were talking about how there was a court across the street, and a church across the street, and those are the parking lots and blah, blah, blah. You had two ways in. Here's one way in. Here's another way in to the court parking lot. All right. So that's what they are talking about. All right. In operation, admission had almost nothing to do with the orders stated. Wait, in operation, admission had almost nothing to do with the orders stated 8:50 a.m. public entry time, because the public seats were few. Members of the public began arriving in the pre-dawn hours, often between 4 and 5 a.m. before court was in session, and while the campus curfew was still in force. Okay, let me get some water. Hold on, y'all. So people were arriving to the court at the crack of dawn, trying to make sure that they had seats. Because you got to think, once the Metcalfs came in and their entourage was there, and Karmelo Anthony's family came in, there was 9 designated seats that were supposed to be there for the press, and then that was it. I don't think anybody really got in there that was general public. Just being honest. And sheriff deputies enforced the order, stopped arrivals at the parking lot, and restricted entry onto the campus until the curfew lifted at 6 a.m. The queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceeding convened. A member of the public who appeared at the court's appointed hour of 8:50 had, as a practical matter, no prospect of a seat. You see that? The line itself was administered without published standards, and not even-handedly. Individuals were permitted to move ahead of members of the public who had already waited for hours. Thelma Anderson, who arrived early on June 6th and initially held approximately the 7th position, was displaced by approximately 35th beyond. She was displaced to approximately 35th in line. So she was 7th and was moved to 35th in line beyond the number of available seats and was excluded from the morning's proceedings. Tamitra Carter, identified as number 7 on the early arrival list, was removed from the line on June 5th and lost the morning session. Admission was run through 2 lines, one for the media list and one for everyone else. The media outlets denied credentials were directed by the public information officer to seek entry through the public line, where, as a Collin County Sheriff's deputy administering the line acknowledged on video, persons who print out whatever to make themselves like they are media consumed the public's few seats and practiced the officers conceded they could not police. A practice they couldn't police. So you had people that were getting on that line and fraudulently creating media passes for them to be able to have access to the courtroom. Shaking my Mickey freaking head. And the police couldn't do nothing about it. They need to go over every case in this county. They thought they could play like all the rest. That part. That damn part. The courtroom had held approximately 70 seats. By the court-appointed public information officer's own written account, 15 were allotted to the prosecution's family. Out of 75 seats, 15 of them went to the Metcalf family. Do you hear me? And then 15 went to Karmelo's family. Do you hear me? 15 and 15 is 30. 75 seats, y'all. 30 seats are already gone. 9 of those seats were for media, including a courtroom sketch artist. So technically, with the courtroom sketch artist, you only have 8 seats for media. And you've got to remember, you're talking legacy media and you're talking social media. You're talking independent journalists, bloggers, YouTubers, TikTokers, Instagrammers. Only 9 seats. Okay? And with additional seats for court staff, leaving about 24 or so for general public. Do you hear me? So I ask you, who was getting in that damn courtroom? Nobody, baby. That's why some people were not getting in there every single day. You see how that went? All right. The trial judge later confirmed the arithmetic on television. Some 200 requests by media and 27 to 32 public seats. They were rotated every day. None of these allocations appeared in any order. And the 15-seat family allotment was not honored in practice. Hello? It was not honored in practice. The defendant's own family was limited to 8 seats in total, so that his grandfather and his aunts were excluded from his trial. Hold up. We are going to read this again. And the 15-seat family allotment was not honored in practice. The defendant's own family was limited to 8 seats in total, so that his grandfather and his aunt were excluded from the trial, while those admitted were required to register a day in advance and were warned that a visible facial expression could result in removal. Now, I know they've been giving us Exhibit 7 and Exhibit 3, but we're going to take our asses right on over here to Exhibit 17. Oh, I didn't even have this up here. I am so sorry. Y'all did not get to see this part right here, but y'all heard it. So now let's take ourselves down here to Exhibit 17. That's a long ways to go, y'all, but let's go on. Let's do it. Are you kidding me? So while they was talking about, oh, he didn't even have any family in there, and he didn't even have any family in there. Yeah, because they were supposed to have 15 seats and they were limited to only 8 seats. And his damn grandfather and his aunt wasn't allowed to get up in that courtroom. Are you hearing this? New trial? Throw the whole damn thing out. Okay, so they said Exhibit 17, declaration of Tony's member of the public excluded from the trial. So let's read this. All right. So this is the state. This is Tony Toussaint, who lives in Baton Rouge, Louisiana. Okay. My name is Tony Toussaint. I'm over the age of 18 and of sound mind and fully competent to make this declaration. I am the grandmother of Karmelo Anthony. I attended the trial proceedings in this matter as a family member to the defendant. Before the trial began, my daughter told me that access to the courtroom would be limited for family members. I subsequently learned that the family was limited to a total of 8 seats in the courtroom. I understood that the remaining seats were reserved for journalists who had been individually selected to attend and for members of the general public. In order to attend, family members were required to arrive at the courthouse at 8 a.m. and to obtain badges. In addition, a family member's name had to be placed on a list the day before in order to be admitted the following day. Before we left the courthouse each day, court staff would ask whether we intended to return the next day so the names could be added to the following day's list. Because I was able to secure one of the 8 family seats, I was able to be present in the courtroom each day of the trial. My husband, Karmelo's grandfather, was not able to attend because of the 8-seat limit on family access. Karmelo's aunt, among others, were likewise not able to attend for the same reason. The judge instructed attendees that we could not speak while inside the courtroom, and we were told that if we did so, we could be held in contempt. We were also told that if we made a facial expression, we would be removed from the courtroom. Stop. Because didn't we hear about how Megan Metcalf was up in there sobbing and weeping? Now, at first I was saying, yeah, you can't really stop a mother from feeling how she feeling. Nah, man, you telling the Anthony family that they can't even so much as make a facial expression or you gonna put them out? But Megan Metcalf can sit up in there and cry? Let me finish. Family access to the courtroom was limited to 8 seats total, which I understood to have been allocated among Karmelo's many family members, alongside seats reserved for selected journalists and general public. Although I was able to attend each day of the trial, the 8-seat limit meant that other close family members, including Karmelo's grandfather and aunts, were not able to attend at all. Attendance also required advance registration each day, and compliance was strict with strict conduct rules inside the courtroom included a prohibition on speaking and a warning that visible facial expressions could result in removal. Well, guess what, baby? I would have been removed because y'all already know my facial expressions. Oh, my face is going to tell it before my mouth ever does. And y'all know that. Y'all know that about me. If you've been around here for a long time, you know that about me. So I'd have been put out the courtroom if I couldn't make a face. Because if it looks like shit, smells like shit, it's bullshit. And I'm going to frown my face up at that's garbage, at the very sight and smell of it. So I guess I would have been put out. How you going to stop somebody from making a daggone face? It's my face. What if it's a nervous twitch? Oh, thank God that wasn't what I thought it was. Okay. All right, let's get back. Let me make sure there's nothing else here. Okay, no, then it goes into Exhibit 18. All right, so let's get back in here. So now we done read Exhibit 17. Ain't this about nothing, though? Let me go on this camera real quick. Do you see why this motion is so imperative and it's important that we're reading through it? Because we're getting answers. Are y'all getting answers? Because I'm getting answers, and I'm getting a little backstory into everything that happened, everything that went on. We're seeing that this case was more unjust than what we thought it was, in my humblest of opinions. What you said, but how is making a face disturbing the courtroom? Girl, your guess is as good as mine, because if I'm making a face, the only way you know I'm making a face is if you looking at me in my face. What you looking at me for? Ain't you supposed to be paying attention to whoever's testifying or the judge? How would you even know? How would they know? All right, y'all, let me get off this camera. Well, maybe I'll stay on the camera. I'll stay on the camera and I'll keep reading just so y'all can see me. Let me take my hair out this ponytail. But now if it starts to get too much for me, it starts getting hot, I'm going to lift this damn hair up, okay? Just so y'all know. But all right, let's continue. All right. Let me turn this up a bit. Yeah, we need to turn that up a bit. Hey, y'all. All right, so it goes on. We've read that already. Defendant's motion for a new trial, the brief in support. All right, so jury selection. The court furnished what its order had never promised. Okay, an auxiliary viewing location outside the courtroom, a functioning overflow room where members of the public who cannot be seated inside observed the proceedings on June 1st and June 3rd of 2026. That is Exhibit 18. So let's go back over here and let's look at Exhibit 18 really quick. My name is Thelma Anderson. So this is coming from Thelma Anderson. Okay, she says, I'm a member of the public. I had no role in the case. I sought to observe the trial proceeding in State versus Karmelo Anthony, which were of substantial public interest. Although the trial was technically open to the public, the practical limitations imposed by the court substantially restricted meaningful public access. The statements below are based on my own observations and on the emails I sent and received during my efforts to attend the proceedings. On June 1st, 2026, I attended the courthouse for the jury questionnaire proceeding. I understood that the questionnaires would be completed that day and that voir dire would begin later in the week. I approached the court coordinator and asked where members of the public would be permitted to observe and whether any accommodations would be available. Given the significant public interest in the case, the court was closed on June 2nd, 2026. Jury selection officially began on June 3rd, 2026. On June 3rd, the court provided an additional viewing location outside the courtroom where members of the public could observe the proceedings. Although court personnel referred to the room by another name, it functioned like it was like what is commonly known as a jury service or holdover room. This arrangement allowed members of the public who could not fit inside the courtroom to observe the proceedings and reasonable accommodation to the substantial public interest in the case. On June 4th, the first day of testimony, the court eliminated the additional viewing space and limited public access to approximately 27 seats inside the courtroom. No overflow room, alternative viewing area, or additional accommodations were provided. Public access was thereafter limited exclusively to the small number of seats inside of the courtroom. Although the court's order specified a time for public admission, the practical reality was very difficult. Individuals began arriving at the courthouse during early morning hours, often between 4 a.m. and 5 a.m., to try to secure one of the limited seats. The process became comparable to a race for access, with members of the public competing for a very small a very small number of seats. Those who arrived after the unofficial line had formed often had little or no realistic opportunity to gain admission, regardless of the time stated in the court's order. So because of these people who were coming earlier than what they were supposed to be coming, people who actually arrived when they were supposed to were not being allowed to get into the courtroom. A hot ass mess. A whole hot ass mess. Yes, getting answers and getting upset the way they treated Karmelo and his family, but the fight goes on. That's right. I believe they said he was making faces, but I know for a fact they said that Megan was in there crying. Okay? In practice, access was determined not by the scheduled admission time, but by how early a person arrived and whether the person was able to secure a favorable place in line. This system effectively excluded many members of the public from observing a trial that had generated substantial public interest. Okay? Because of these restrictions, I was unable to gain entry to the courtroom on June 4th. If there had been an overflow room, I would have went to the overflow room. On June 5th, I again attempted to attend the proceedings, but was unable to gain entry because of the limited seating and admissions procedure. All right, so that's letting us know. Give me 1 second, you guys. I do apologize. Give me 1 second. I'll holler at you after. All right. Sorry, y'all. That was Dogface. Shout out to Dogface. Y'all know I do my podcast with Dogface. All right. So we've read what Thelma had to say. All right. So now they're probably just going to go over. And you know what? I think I'm going to stop reading the evidence because it looks like they give you like a brief synopsis of what the evidence is already. Because I see already it says on June 1st, the first day of testimony, the court eliminated the overflow room. So basically, I'm going to stop reading the evidence and let's just stick with the court docs. Okay. That was a good idea in theory, but right now, we're going to keep going with what we're doing. All right. Okay, so let's read the last bottom part right here. When Thelma Anderson, okay, so we read about Thelma, okay? Media request intake, overflow room, When Thelma Anderson asked the court for an alternative viewing location, there was no way even to file the request. The county's electronic filing system had no category for courtroom access requests in a criminal case. So the request was routed by email to the court coordinator and on the public information and on to the public information officer, and it was denied outside any judicial proceeding. On June 5th, the public information officer confirmed in writing there is no overflow room. I bet you they won't make this mistake again. You heard me? All right. So the pattern is visible day by day during jury questionnaires and voir dire. June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, that room was eliminated. And on every documented day of testimony thereafter, members of the public were excluded. The accommodations existed precisely when no witness was testifying and vanished precisely when the evidence began. Ain't that some bullshit? So you're going to allow the public to watch the jury get selected. You're going to have an overflow room for that to be observed. But then when we start getting into the trial, the nitty gritty of everything, you did away with it. Disgusting. Disgusting. Nah, she good right now, uniquely. All right, so they gave us a whole, this is right here is showing us that on June 1st, jury questionnaires auxiliary viewing room was available. Okay, they gave you the rooms, no court, the 3rd, and then it says on June 4th, testimony begins, viewing room eliminated. Viewing room eliminated. All right. The exclusions that followed were replaced were repeated and concrete. Jacqueline Yon traveled from North Carolina and on the first day of testimony found a line of roughly 80 to 100 people, from which only about 27 were admitted. Hold up. There was about 100 people out there and only 27 people were admitted. Whew. Tierra Allen flew in from Arizona, observed jury selection from the auxiliary viewing room, was told on June 4th that the room had been eliminated and was excluded from the courtroom on June 4th and 5th. Bridget Smith attended on June 1st, 4th, 5th, and 6th and confirms both the roughly 27 seats public cap and the elimination of outside viewing location once testimony began. Kiera West was turned away on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th because the expressive content of her clothing. Thelma Anderson was excluded on June 4th, 5th, and on June 6th, was seated only in mid-afternoon after substantial portions of the day proceedings had passed. Throughout, no declaration observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain this restriction. Okay? The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Now let's get into it. Beginning early May 2026, the lead prosecutor proposed that the parties try the case clean, based only on what happened under the tent that day. Oh, shucky ducky quack quack now. Hold up. Wait. Damn it. My glasses need to be cleaned, but I need my damn glasses for this because I don't want to miss a word or skip a beat. Do you hear me? I don't want to miss a word or skip a beat. So let me get my glasses on because we about to get into it. Let's hear what they got to say. Shout out to everybody who is in here rocking out. Be sure that you're leaning on that like button and share this video out. Share this video out. I do understand that my channel is acting really janky right now and people are not getting their notifications and such. But please share this video up if you know somebody who would like to get into all of this. All right. So let's make sure we got these glasses together because we're going to get into this. Now let's start again. The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, lead prosecutors proposed that the parties try the case clean based on only what happened under the tent, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. So they were not supposed to go into any type of character or reputation or extraneous conduct evidence. They weren't supposed to get into that. So all of that with the damn prosecution talking about who was the agitator, who initiated all of this. They wasn't supposed to be doing none of that based off of the agreement to try the case clean. Y'all picking up what's being put down? Let me know. The terms were negotiated in a meeting and calls on May 5th, May 8th, and May 11th, and on the 21st. The parties presented understanding to the court itself in chambers off the record. I'm going to say that again, in chambers off the record, to avoid media reporting on bad act evidence. The understanding was memorialized only as a deliberately generic motion, hand delivered to the court on the first day of trial. It does not appear in the public docket. Did y'all hear what I said? Did y'all catch that? They made this try the case clean agreement off the record. And the only way that it exists is through a hand-delivered generic motion. Oh, baby. Oh, we go into it. What they said, Exhibit 10. Is that Exhibit 10 and 2? Hold on. Oh, we got to see this. Oh, I don't know if we're going to read all of that. Oh. Mike Howard. I don't even need my glasses for this shit. I, Mike Howard, was the trial counselor. I just skipped over that whole first sentence, okay? Supported by the second chair co-counsel Toby Shook, third chair co-counsel Tasha Gupita, and briefing appellate counsel Michael Maula, who represented Karmelo Anthony in cause number blah, 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 leading up to June 1st, 2026, trial of this case. So, the lead prosecutor in the case, Bill Werski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, under the Memorial High School tent. okay, at the stadium on April 2nd, 2025, and not go into character, reputation, or extenuous offense and or bad act evidence applicable to either Austin, Hunter, or Karmelo. So they were entering into an agreement where they could not mention any of this is what, hold up. Get this back for a second. Hold up. Wait a minute. Wait a goddamn minute. Hold on. Do y'all realize what we just read? They didn't want any character, reputation, extenuous offense, or bad act evidence against either Austin and Hunter Metcalf or Karmelo. Since the trial, that cheerleader email was very detrimental to this case. Y'all do understand that, right? Because it spoke to their character, their reputation, extraneous offenses, and bad act evidence. This agreement had absolutely nothing to do with Karmelo and everything to do with protecting the Metcalf twins' reputation. You said, where was Karmelo's so-called lawyer to object to this? They agreed to this, King CJ. His lawyers agreed to not allow any of this to come into trial. They wanted to run the case, quote unquote, clean and keep it to what happened underneath the tent. And because they kept it to what happened underneath the tent, they were able to demonize Karmelo Anthony. Those lawyers agreed to protect those twins, even with Karmelo Anthony's life on the line. Give this boy a new trial and have the truth come out. Because I'm telling you right now, I don't believe that Austin Metcalf was the aggressor that day. I believe Hunter started that shit and Austin went to go finish it. Just like his brother said in that interview. And I know a lot of people are talking about that video and it was altered and it was fake. I pretty much stand on what I saw in that video. I believe the Metcalf twins tried to jump Karmelo. There it is. There it is. I'm going to read it one more time. When mentioning the proposed agreement, Mr. Worski proposed that we try the case clean, which he defined as based only on what happened under the tent that day, and not go into character, reputation, extenuous offense, and or bad act evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. So they protected these boys all the way. On May 5th, Mr. Shook and Mr. Worski discussed the proposed agreement by phone. During the call, Mr. Shook and Worski discussed the evidence of character, reputation, and extenuous offense bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Worski reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet. This is some motherfucking bullshit. If y'all don't get this boy a new trial and y'all don't tear motherfucking Collin County up, I don't know what to say. On May 8th, the defense and the prosecution teams met in Collin County grand jury room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extenuous Offense, hereinafter state notice. And we gave to them a document entitled Anthony's Motion to limine regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor role, the evidence under text code criminal. We're not getting into any of that. Okay, defense notice. After tendering to each of the other respective extraneous filing briefings, we then discussed the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. Mr. Worski outlined the proposed agreement as follows. Both sides try the case without character, reputation, or extenuous evidence for either the Metcalf twins or Karmelo Anthony, and just try the case based on what happened under the tent. And during another description during that meeting, what happened on the day of the incident. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extenuous offenses, act or acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins' school records within this time frame. As well as racism. Let me read this again. And I'm going to read it without raising my voice. Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses, acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins' school records within this time frame, as well as racism. In exchange, the prosecution would not go into character, reputation, and extenuous offenses, act or acts, evidence relating to Karmelo Anthony, inclusive of contents of Karmelo's cell phone and school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, how to handle the possibility of repeatedly express, wait a minute. My mind just went kaboom. Give me a second. Let me sip some water for a second. My blood boiling right now. You want to tell me that this ain't no good old boy shit that we reading? You want to tell me that this was a fair and just motherfucking trial? Where all them people at that was coming in these comments with all that hateful racist shit that they were saying? Where they at? Where they at? Where they at? Because what I want y'all to pay attention to and what we just read and what's like boggling in my mind right now, like really like going, is when they start talking about the things that they're not going to mention, right? When they talk about the things they're not going to mention, they talk about the character, the reputation, extraneous acts or act or, et cetera, et cetera. But when they talk about the Metcalf school records, they say the school records within this framework. as well as racism. When they get to Karmelo Anthony, the additions to Karmelo is his cell phone and school disciplinary records. Well, we already had the girl that was interviewed that said that she was surprised that Karmelo, she only knew him for fighting. So obviously he had some school fights and scuffles. But there's no mention of racism on what they couldn't mention when it came down to Karmelo. So why are we mentioning racism with the Metcalf twins, huh? Huh? Yeah. Yeah. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening the door to this evidence from either side. During the meeting, Mr. Swirsky repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses by witness interviews by police and captured by video on the day of the incident. So they have witness statements that were captured on video from the day of the incident. Were those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected, etc. Isn't that what their mother said? They were told to change their testimony. They were coached on it. There's no getting around it. I'm getting heated. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific statements the witness made to police about the incident under the tent on April 2nd, including statements just described about the mindset and actions of the parties involved in the incident, would not constitute kicking open the door and thus would not violate our proposed agreement. During this meeting, we discussed the terms of agreement, being that testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April 2nd, 2025, would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of defense calling experts. The prosecutors only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt/innocent phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt/innocent phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extenuous offense/act evidence. So the reason they never got anybody to come up there and testify to the fact that Karmelo had epilepsy is because of this agreement. The answers are here, and the chickens are coming home to roost. Y'all are hearing it for yourselves. So the witnesses could get on the stand and they could testify. And that wouldn't kick open the door. But if you bring a witness on the stand to testify to his epilepsy and how it put him into fight or flight mode, that it would violate the agreement and open the door to character, reputation, and extenuous offense acts evidence. That's why Karmelo ain't want to get on the stand. Let's continue. Lifeboy TV, you ain't never lied. He said, you get hit in your head, have a seizure, game over. They wrong. Yes, passionate meaning aggressive. That's not a character trait, though. They did him dirty. Big time, big time, big time, big time. On May 11, 2026, Mr. Worski, Dewey Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During the phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if a thing occurred, he will respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard. I love my son. Please show mercy type testimony, but no further. This is why she gave a basic testimony. And let me explain something to you and how this makes Jeff Metcalf such a despicable, vile human being. He knew about this agreement. He knew about this agreement. And then he got his ass on that camera with Sarah Fields and painted such a dirty narrative about Karmelo's mother. They trusted their lawyer too much. I want to cry for this boy. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreed not to get into character, reputation, etc., etc. We know already, as it applies to both sides during both guilt, innocence, and sentencing phase, as long as no doors are open or false impressions given. We agreed that the best way to document such agreement would be for the defense to draft a file motion. I don't know how to say this word. Lemine? Is that how you say it? Come on, let's find out together. Let's find out together. I cannot believe this. I have such an attitude right now. I have an attitude. I can't believe
in limine.
Limine? No, it's not in limine. In limine. Okay. In limine, applying to character, reputation, and extenuous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad acts, evidence specific to certain witnesses, thus endangering a fair trial. This is why the judge needs to be recused. As a judge, you sat there and you listened to this agreement. And you allowed this backdoor, good old boy shit to happen in your courtroom. He needs to step down immediately. And they need to do a full investigation into every case that this judge has sat on and presided over in Collin County that includes any person of color. I don't give a damn if it was a parking ticket. Do you hear me? And they made the defense file it. And they went for it. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand delivered to the judge on opening day of trial. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description by Mr. Worski described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would any other eyewitness to the incident under the tent in April 2025. Following the plain meaning of Mr. Worski's words in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses such as memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. I'm getting upset because I already see where this is going. This understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement was drafted and tendered to the prosecution. On May 29, 2026, after a meeting with Judge Roach, the prosecution and the defense to discuss how trial security would be handled, the parties discussed the timing of the state's case in chief and when the defense's case in chief would start. Mr. Worski informed the courts and defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended on Saturday, June 6th. In response, I voiced concerns to the judge in front of the prosecution team that some of the witnesses and defense anticipated calling to testify were unavailable on Saturday, June 6th. I explained that, like in any case, I would not know until the final moment whether we could call our client for sure. but that if the prosecution rested sometime Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up a full day of testimony Saturday. I explained that if this happened, it would force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish certain facts and then conclude by calling our client to testify as our last witness. On Friday, June 5th, the second day of testimony during the state's case in chief, I checked in with Mr. Worski about how he was proceeding and whether we would end up taking more or less time to present his case in chief than he likely had estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated, so the prosecution was on track to rest its case in chief midday Saturday. In this conversation, Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday. And if the judge proceeded with this plan to force the defense to call witnesses immediately upon prosecution resting in order to have a full day of testimony on Saturday, he might be forced to call our client out of order. This time I did not preface the statement and was perfunctory. I don't know. I don't even care what he said at this time. Like in any case, I would not know if I'm going to call my client at the last minute because I was not on the record and was speaking frankly with opposing counsel. I was very plain about the defense's intentions to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June 5th, this conversation with Mr. Worski occurred, but it must have occurred just before noon because I then sent an email to Michael Mauler describing the problem we were facing and asking Mr. Mauler to draft a brief for us to argue to the judge that he could not force us to call our client out of order. Throughout the morning and early afternoon of Saturday, June 6th, Mr. Shook and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the defense team repeatedly mentioning in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order, Mr. Worski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify. Even before both sides tendered their notice and arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to other sides' witnesses, Mr. Worski made references to understanding that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated and unknown to Mr. Anthony via the ambiguous aggressor rule. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the descendant in the murder case are all part of self-defense argument. Tories discussed in depth how ambiguous aggressor rules allow the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. Mr. Worski repeatedly brought up Torres and discusses with the defense team in the months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that character evidence could be allowed. This repeated a discussion of Torres and how it may apply to the trial, showed that Mr. Worski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. This was the entire purpose of the agreement in that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Hunter and Austin and Hunter Metcalf, and the defense from the defense's perspective The entire agreement centered around the defendant testifying without impeachment by character, reputation, or extenuous evidence in exchange for the defense not seeking to introduce character, reputation, extenuous evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony, free of impeachment. Just like every other witness, either side could have testified about what happened under the tent that day. I think we all know. I think we all know where this is going. Throughout the trial, the defense revised its trial strategy in reliance upon the agreement. Absent the agreement, the defense intended to cross-examine each memorial student witness. The prosecution called about Austin and Hunter Metcalf's character, reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements they had made to the police on April 2nd, 2025, regarding Austin and Hunter Metcalf being easily triggered, having a loud mouth, and being passionate, not allowing themselves to be disrespected. Some specific examples include Austin's a really big guy, and he's kind of like the aggressive guy on the team. Austin got the same way that he got during the altercation is the same way he got with some of us. And the mellow kid, something or whatever. And then Austin kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's really a passionate guy. And Jose told police that Austin's history of fighting and almost getting kicked off the football team for fighting. I've known Austin for a while, and if Austin is about to get into a fight, you could tell. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins' violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. They are exactly what we said they were. In good faith reliance upon the agreement, the defense did none of this. The defense even limited its questioning of witnesses about statements they had made about the Metcalf twins being triggered, having loud mouths, being passionate, etc. That had been deemed to be allowed under the agreement in the abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychology-related expert would open the door to character, reputation, and extenuous evidence pertaining to Karmelo, the defense chose not designate any expert and ultimately chose not to call as a witness a neuropsychologist to discuss how Anthony's epilepsy impacted his perception of threat and response, as that is relative to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applies to Anthony's actions. As a result of this revision, the defense in the defense strategy, the defense did not go into the subjects during voir dire or opening statements. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire, would have introduced these topics during its opening statement. In sentencing, in reliance upon agreement, the defense did not designate an expert who was ready to testify regarding mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Other than general character testimony and pleas for mercy in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been victim of in his home. On Saturday, June 6, 2026, after the prosecution rested its case in chief, the defense called witness Adam Lynn Wood, Jeremiah Smith, Jose Andre Ramirez Mora, before ending the day in the late afternoon, early evening. On Monday, June 8th, the defense resumed its case in chief, calling Brandon Steffens and Brennan Lancey. The defense's next planned witness, Blank, had been avoiding the defense subpoena and kept changing the time. He told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if Blank had arrived. During the 10:50 a.m. break, in the back hallway outside the judge's chamber, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach. Mr. Worski asked what the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that the testimony about epilepsy was irrelevant at guilt and innocence, and to the extent it was relevant, would open the door to character, reputation, and extenuous evidence against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, and that it did not relate to character, reputation, or extenuous evidence in any way. But Judge Roach agreed with Mr. Worski that he thought testimony about epilepsy was not relevant during guilt innocence and would open the door to character, reputation, and extenuous evidence. Based on this, I informed the court that I would not call the coach and that I anticipated having 1 to 2 more witnesses before I called Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decisions regarding testimony. But I was 99% sure he would in fact testify. So they were talking to him about Fifth Amendment rights. You were going to have that boy plead the Fifth? After a break, back in court before the jury, to give Blank more time to arrive at the courthouse, we then called Frisco Police Department Detective Riley to testify. After Detective Riley finished testifying, I then decided to call Blank as a witness, and we broke for lunch around 11:17. And the prosecution and defense team stayed behind to talk to the judge outside the jury's presence. On the way back to chambers, Mr. Worski mentioned to Mr. Shook that, from his perspective, I had already opened the door to character, reputation, and extenuous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. Jesus Christ. Jesus Christ. And because the prosecution had already stopped their case, there was nothing that they could do at this point in time. And I seen this coming. They set this boy up for failure. I did not say anything about a chess club at any time during my opening statement. I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me, and Mr. Worski and Mr. Mitchell, Mr. Shook and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. Back in the judge's chambers, Mr. Worski repeated his assertion that the agreement between the prosecution and defense never contemplated a testifying defendant. He elaborated, stating that he had never thought we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying Mr. Anthony was a member of the chess club. It is important to note that this was the first time Mr. Worski mentioned that he believed I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense team had conferred many times throughout the prosecution's case in chief about various issues, this was the first time Mr. Worski brought up this assertion. Judge Roach told both the prosecution and defense teams that my mention of chess during the opening statement definitely did not open the door to character, reputation, and extenuous evidence applicable to Mr. Anthony. The parties argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position that it did not, and if we called Mr. Anthony to testify, character, reputation, and extenuous evidence pertaining to Mr. Anthony were in fair play. Furthermore, Mr. Worski stated at that time that the prosecution already having rested character, reputation, and extenuous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was, that the first aggressor was clearly Austin Metcalf. At this point, the discussion developed into a shouting match. After the breakdown of the agreement, the defense and prosecution teams agreed to take 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony, should the defense now choose to call him. After about 10 minutes cooling off period, Mr. Worski and I met in open court outside of the presence of the jury and without the public in the room to discuss possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would open the door to the agreement being breached. That's all. I'm tired of saying this shit over and over again, okay? To the evidence being breached pertaining to Mr. Anthony, especially his repeated claim, even after the judge stated otherwise, that my mention of playing chess opened the door to character, I resolved that my only choice was to go over my plan outline of Mr. Anthony's direct examination line by line with Mr. Worski to determine what would and would not, in Mr. Worski's view, open the door. Now stop. Why do you have to give him a play-by-play so that he can counteract? I've never heard of no shit like this before in my life. What kind of lawyers are these? This did not help him in any way. You backed him into a corner and jammed him up. You put him out there on the blade. I have never taken such a drastic step of previewing my strategy and even my questions with a prosecutor. Exactly. So he knew what you were going to do. That's what that was about. And he could counter. But as a defense team, we agreed that we had no other option if we wanted to try to reach an agreed understanding with Mr. Worski of how the renegotiated agreement would cover Mr. Anthony's testimony. As I went through my outline, Mr. Worski standing, reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to violating the agreement pertaining to Mr. Anthony. During this discussion, Worski repeated his claim that my earlier mention of chest opened the door. While I disagreed with all of Mr. Worski's assertions of subject that would open the door, I agreed to cut them from my questioning in hope of salvaging the agreement to keep Mr. Anthony's extenuous offenses out if he testified. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of testimony in the abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. We then summarized the process we had just gone through and our renegotiated agreement on record. Prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being opened. For example, if he said that he bought the knife by accident or said that he was scared, etc., that would almost certainly open the door to character reputation and extenuous evidence of some sort. I can't read. I need a break. I need a break. I don't want to read the rest because I'm getting heated. We all said they railroaded this boy. People have said that he was systematically lynched. We're reading it. We're reading it right now. They took him out to the slaughter. How could y'all do this? How could y'all do this to a young man? I hate to be right. This boy didn't stand a chance. They set him up to take the fall. I would not be. You said who gave this information to the new team? It's in the case file. It's in the case file. This is a statement that the previous attorney wrote. This ain't the new attorneys talking. This is one of the previous attorneys talking right now. You must have been late, Miss Black. They definitely need to be disbarred. They need to be sued for malpractice. But they didn't just set him up. They set the family up too. To preserve the Metcalf twins. And Jeff Metcalf, he runs his mouth so much Because remember when he talked about how they allowed the video to be shown, how they messed up when they allowed the video to be shown? I don't know who you are, Bluey Cluey, and I don't even know if you're being funny. My heart aches for this boy. He knew. He just was so smug, and he just knew this will never come out. To clarify the issue, I proposed a hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, if I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement. So, here's the thing. The judge couldn't enforce the agreement. And that's what I just explained to you. This is coming from the old attorney. The previous attorney typed this up. This is evidence in the appeal case. That's how they got this. Because the previous attorney, one of the previous attorneys, sat down and typed all of this out for them. It's in the file. So this is not the new attorneys reiterating something or regurgitating something that was given to them. This is the previous attorney. Ooh, baby, this case has got me like... If I and even the judge felt that So the judge is already letting it be known that no matter what Mr. Worski does, the judge cannot enforce anything. So there's nobody to back up the defense at all. They're all on the same team. Judge Roach and the prosecution on the same team. Why would they enter into this agreement? Anyway, the judge would have to make a ruling based on the Texas rules of evidence alone, and that in all likelihood, the door would have been opened. Judge Roach confirmed that this was the case. We then broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for an on-the-record admonishment. You got 10 minutes to tell your client You got 10 minutes to tell your client that they're not going to be able to testify on their own behalf because of the agreement. Y'all hands are tied. During the initial meeting with Mr. Anthony and his parents, I did my best to explain everything that had just happened with the help of Mr. Shook and Miss Gupta. I don't know. The female bad attorney. We then returned to the courtroom for Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and to also explain that if he testifies, Judge Roach believes that he has no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach gave us 10 minutes to discuss the Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify. So you put this young man's life, you estimated making a life-altering decision. You broke that down into 20 minutes. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined. He declined to extend our time beyond 10 minutes. Again, we did our best to explain everything, the pros and cons of testifying versus not testifying, the likelihood of winning on self-defense if he testified versus if he did not, the likelihood of whether we would get instructions in the jury charges on the lesser included charge of manslaughter and criminally negligent homicide if he did or did not testify, and the likelihood of whether he could get instructions in the sentencing jury charge. If we got there on sudden passion, if he did and if he did not testify. During the discussion beyond all of the above, the most complicating factor of all was whether Mr. Worski would claim that we had opened the door and then bring in Mr. Anthony's extenuous offenses, bad acts, character, and reputation. Based on his actions and claims, specifically, he repeated assertions even after the judge had firmly disagreed that I had opened the door by even mentioning Chest, as well as his general claim that the agreement had never contemplated Mr. Anthony testifying, despite the plain meaning of the words Mr. Worski himself repeatedly used to describe the agreement. The defense team felt strongly that the risk of Mr. Worski claiming the door had been opened was too high. This was amplified by the fact that Judge Roach made it clear that should Mr. Worski claim a breach of agreement, he felt he was able to enforce it, and that in all likelihood, the door would have been opened. At the end of 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision to proceed with trial. Ultimately, Mr. Anthony did not testify. This 180-degree change in the defense strategy was the direct subsequence of the breach of agreement. The breach of the agreement affected all aspects of the defense case. By the time that agreement was breached, it was too late to change our position in voir dire and opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses to ask questions that would risk the prosecution deciding we had opened the door. It greatly hampered our strategy during sentencing, causing us to decide not to call witnesses we otherwise would have called, and severely limiting the questions asked of the one witness we did, in fact, call. The prosecution's breach of agreement directly and significantly undermined the defense's ability to present a complete defense. Okay, wait a minute. Hold on. If you ask the question 9 times, darling, I'm reading. I ain't reading the chat when I'm reading, so I ain't see it. But if you've been paying attention, then you would have known that I've been flipping back and forth between the evidence. And right here, it says Mike Howard, affiant. This was his affidavit, his sworn affidavit. Trial counsel for defendant Karmelo Anthony sincere. Okay. Look, tensions are high right now. Please, not in the chat. Like, I'm trying to keep myself together while reading this. Okay, and according to this right here, we haven't even really cracked this thing open yet. We're on page 8 of 63. Okay? And it's after midnight. How long we done been in here already? We done been in here 2 hours. So now we know why Karmelo didn't get on the stand. We didn't know why at first. Now we know. Now we know why the defense didn't do some of the things that they did. But you know what? The prosecution was quick to call out foul anytime they felt like it, but the defense did not. And they had every right to call foul on the prosecution. Thank you. Please. They fumbled this kid's case. At one point, I was about to cry. I'm not even going to lie to y'all. I really, my tears were welding up and I was holding them. I can't believe what I just read. From that point forward, the defense tried its case. Now we're back to the motion for the new trial. Okay. So we read the evidence and we're coming back over here to the motion for the new trial. That was the evidence. That was the affidavit given. That was the affidavit that was given by the previous attorney. Now we're back into the motion for a new trial. Okay? I'm with you, LaShonda. All right. Let's start again. From this point forward, the defense tried its case under that limitation. At every stage in reliance on the bargain. In Vaudere on June 3rd, the defense did not explore with the panel the themes of the descendant's character and aggression it otherwise would have developed. In its opening on June 4th, it introduced none of them. Through the state's case on June 4th, 5th, 6th, the defense let the state's student witnesses leave the stand without confronting them with their own recorded statements to the police. That Austin Metcalf was kind of like the aggressive guy on the team and that he got triggered. That Austin and Hunter were not going to let you disrespect them. And that if Austin is about to get into a fight, you could tell. And that he could be a bit aggressive at times. And in an abundance of caution, even narrowed the questioning to understanding permitted. To understanding permitted. The defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perspective of threat, and a forensic psychologist prepared to address adolescent brain development and fight or flight response, because the state took the position that such testimony would breach the understanding. The forbearance had a purpose. The payoff was to come in the defense case. The payoff was to come in the defense case under the understanding that the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free from character impeachment, and the defense would present its self-defense case through him. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in a self-defense case built on such evidence, and as trial counsel has sworn, in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. On Monday, June 8th, the final day of evidence, after the defense had spent voir dire, its opening, the entire cross-examination of the state's case, and the first days of its own case honoring the bargain. The lead prosecutor announced that the agreement had never contemplated a testifying defendant, and asserted that defense counsel had already opened the door by mentioning in opening that defendant played chess, a position the court itself rejected. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding. An understanding that throughout the months the defense relied upon it, existed on no record because it had been reached and presented to the court off the record, and that if the defendant testified, the door to character and extent, oh my God, the agreement, I don't want to repeat that word ever, would almost certainly open. Allotted 10 minutes, the defendant elected not to testify, but then it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses, and at punishment, the defense case was reduced to 3 approved questions of the defendant's mother. The state, for its part, called no punishment witnesses and offered none of the extenuous offers or character evidence cataloged in its 75-page notice, resting its punishment case immediately. Exactly as the lead prosecutor has described, by May 11th, that agreement would operate. The state thus performed the bargain at punishment the day after denying that some of the bargaining covered the defendant's testimony. In the end, neither side put on the character evidence the understanding covered. Neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only turn repugnant was the one most vital to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding as the state itself had repeatedly described it. He would testify like any other tent witness. And his elimination as a witness was devastating to the defense that turned on his own perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire, opening, cross-examination, expert designations, and decision framework that had followed from the understanding. They really screwed him over. Thank you for the super chat, Stacy. First time viewer, but I subscribe. Well, welcome to the bar, LaShonda. I appreciate you. They did this strategically. Remember how I kept saying the good old boys, they already had a system. They all worked together. I believe this Toby Shook guy may have been in on the shakedown too. I'm sorry. Mike Howard was like, I wasn't a part of this. I just went along. but you were still a part of it. I don't give a damn. He's a snitch. Mike Howard, we appreciate your testimony, but you went along with it. And you put everybody out there and made it seem like you were just this innocent bystander, but you were right along with them for the ride. Knock it off. The trial itself was run at speed. At the May 29th conference, the court announced its intention that the defense could begin calling witnesses immediately upon the state's resting so that no trial day could go unfilled, including Saturday, June 6th, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call the defendant out of order. The state rested midday Saturday, and the defense began its case that afternoon. Well, this is just going over what we already read, so let's get to the part. The court delivered its charge. The parties presented closing arguments. The jury deliberated approximately 3 hours before finding the defendant guilty of murder. Hold on. The defense rested the day after the shortened session, which was when the defense decided to close the case. And they're saying in here that the jury was sequestered for the night. The defense rested that day after the shortened session, and the jurors were sequestered overnight in a hotel. Thank you very much for the super chat, Miss Black. I appreciate you. Oh, shoot. Stacy is a member. Welcome to the other side. Thanks, you guys. Okay, informed that if they did not reach a verdict on Tuesday, they would resume sequestered. They would remain sequestered. On Tuesday, June 9th, the court delivered its charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder, the punishment phase, evidence, argument, deliberation, and the rejection of sudden passion. When they completed and the 35-year sentence imposed was then completed and the 35-year sentence imposed before the day ended. The sequestration and deliberation chronologically, widely and publicly reported, will be established at the hearing and confirmed by reporters' records. The secrecy outlasted the verdict. Trial counsel withdrew on June 10th, 2026, appointed appellate counsel, and was then replaced. And the present counsel are were substituted in on June 23rd, 2026. Hey, that's Peanut Butter's birthday. All while the third-party deadline for this motion ran, the reporter's record remained wholly untranscribed, and the pleas of the case file sat in the court's chambers rather than in the... Wait a minute. Hold on. All while the 30-day deadline for the motion ran, the reporter's record remained wholly untranscribed. The reporter's record was not... Is this why we don't have a transcript? And the pleadings and case file sat in the court's chamber rather than in district clerk's public records, sealed by an oral order. This is why we can't get shit. They haven't sealed anything. They're sitting in Judge Roach's chambers. Do you need me? Oh, okay. At the conference on June 29, 2026, the court advised that the entire court file had been sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. A condition counsel could not give, leaving the file available only in chambers. 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks maybe he should have at least audio streamed or something so people could hear it, and explaining that he decided to do so because people are going to distort whatever happens. So what's the point? In a written statement to Fox News, the judge added, "Now that the trial is over, it's important for me to provide transparency." Now you want to be transparent? Now you want to be transparent? Let's go to Exhibit 5. Matter of fact, we ain't got to go to the exhibits because remember, we already get a breakdown here. So I just wanted to read that affidavit. Unless we have to go over there, I don't want to keep you guys up no later than I have to. It's already 1 a.m. We've been here for a while. All right, so let's continue. And in a public letter of June 17, 2026, he thanked the other judges of the county for adjusting their own dockets to accommodate this trial, at minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. And because the case file had been held in chambers rather than in the district court's public record, the recitation above is drawn from the indictment. The court's charge, the public docket, the court's own orders and public statements, the attached affidavits and declarations, and counsel's knowledge. Defendant will offer evidence at the hearing in support of the grounds timely raised herein. I personally want to thank Neek at Night. I want to thank Queen Sheba. I want to thank Mel from Watching the World. I want to thank Gerald from the North Carolina Beat. For transcribing this trial. Those who took notes in that courtroom may very well have the only true and honest transcripts from the trial. Wow. My mind is blown. How is this even allowed to happen? How does a judge get to hold court records and a transcript not be transcribed? And because the case file has been held in chambers rather than in the district court's public record, I read this already. On June 9, 2026, a jury found defendant guilty of murder, and on the same date, the court imposed sentence in open court, assessing punishment at 35 years confinement in the Texas Department of Criminal Justice Institution Division. On June 4th, 2026, a trial court signed the certification of the defendant's right to appeal. Although the certification issued before the Although that certification issued before the verdict, the judgment of conviction was rendered and the sentence imposed on June 9th, and the notice of appeal followed. On June 10th, 2026, the defendant filed his notice of appeal, and the appeal was docketed in the Fifth Court of Appeals. On or about June 11th, 2026, after the verdict, the sentence, the certification of the right of appeal, and the filing notice of appeal, the presiding judge gave a televised interview concerning the case, which aired on WFAA TV Channel 8. While all this stuff was... This motion is timely under Texas Rule of Appellate Procedure 21.4a, being filed within 30 days after June 9th of 2026. The date sentence was imposed in open court. The court retains authority to consider the rule on this motion through a 75-day after the date and notice of appeal, if any, does not divest the court of that authority until the appellate record is filed in court of appeal. Because sentence was imposed in open court on June 9th, 2026, the 30 days to file this motion is July 9th. The 75th day falls on Sunday, August 23rd, 2026. Subject to Texas Rule of Appellate Procedure 4.1, defendant requests a hearing and ruling no later than August 21st, 2026 to avoid any dispute over Rule 21.8's deadline. So the appellate court, they're telling them you have until August 21st, Friday, August 21st. So go ahead, have a hearing on this matter, and rule. There are no transcripts, Latrina. There are no true transcripts from the court. What you're reading, hey, Sherm, I just asked about you earlier today. What you're reading from CBS is what you get from Inner City Press, which is not a full, true transcript. It is their synopsis of a transcript. What you get from Gerald, Mel, Queen Sheba, and Nick at Night is a handwritten transcript. I would follow their transcripts better than the CBS one. But there is no true transcript. Comprehension skills for who? For who? The judge in interview said they all met months before the trial and discussed everything. Well, it's right here. They did meet and discuss everything. And I just read in this motion for a new trial that there are no transcripts. The court reporters' reports have not been transcribed. They're sitting in the judge's chambers, along with filings that should be on record. Hey, Purple Doll. But anyway, they're giving the appellate court until the appellate court. Well, I'm not going to say they're giving. The appellate court has until August 21st for this. That is sickening that the transcript does not exist. Yes. I'm going to go back for people who just came in. For the people that just came in, I don't want to go too far back. Right here. Because the reporter's record of trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. And because the case file has been held in chambers rather than in the district clerk's public record, The recitation above is drawn from the indictment, the court's charges, public dockets, the court's own orders, public statements, and attached affidavits and declarations, and counsel's knowledge. So they're saying basically that they're going off of what they could get from people who were there, statements that have been made, what is on the record, what's publicly known, and through affidavits that people have filled out for them. So far, we've read an affidavit from Mike Howard. We read an affidavit from Karmelo's grandmother showing that she was allowed to get into the court, but that instead of them having 15 seats, they were reduced to 8. And that his grandfather and his aunt were not able to get into the courtroom. Meanwhile, the Metcalfs had their 15 seats. Go figure. Okay, so let's continue. Defendant is presenting this motion within 10 days of filing, as Rule 21.6 requires, and contemptuously requests that the court sign and attach order in presentment and set the motion for an evidentiary hearing so that the parties may present evidence and that the court may rule within the time Rule 21.8 permits. Contemptuously, with the motion, the defendant is filing a motion to recuse the presiding judge. Because of Rule 18A of the Texas Rules of Civil Procedure Government, recusal in criminal cases. Defendant requests that the evidentiary hearing on this motion be conducted by the judge presiding after the recusal motion has been referred and resolved in accordance with that rule. This motion is supported by affidavit because it rises matters outside of trial court established by the attached affidavits and authenticating declarations. And as is timely filed and presented, defendant is entitled to an evidentiary hearing, and the court would abuse its discretion in denying one. Under these circumstances, refusal to hold a hearing would be an abuse of discretion because the motion and its supporting affidavits raise matters not determinable by the existing record that, if true, could entitle defendant to relief. That is especially so here, where the reporter's records has not been prepared. The official court reporter has advised counsel has no portion of the trial as yet has been described. No portion of the trial has yet been transcribed. So the relevant proceedings cannot presently be reconstructed without any existing record. There it is again. There is no official record. The issue is whether the court had authority to manage courtroom security and capacity. It did. Oh, the issue is not whether the courtroom had authority to manage courtroom security and capacity, because it did. The issue is, after adopting an access order that foreseeably excluded members of public from a high-profile criminal trial, the court made the finding, Waller versus Georgia, requires and considered the reasonable alternative, demands for contemptuous public access. It did not. The court gave the general public only a 10-minute delay initial admission window, left roughly 24 seats for public observers in a nationally watched murder trial, barred meaningful re-entry during proceedings, and provided no overflow room, no audio feed, no video feed for those foreseeably turned away. Once closure is shown, it cannot stand unless the record contains a Waller-compliant justification for those restrictions, and the existing record contains none. Nor does the danger end with this case. In a televised interview about the case that has drawn national attention, the court publicly defended their restrictions as the right way to conduct a high-profile trial, describing the decision to bar cameras and streaming as an easy decision, and stated that it had struck that balance pretty well. Should a trial held behind a 10-minute entry window with no overflow room, no audio feed, no live stream be treated as an adequate substitute for an open court? The public trial guarantees the public trial guarantee of the First and Sixth Amendment would be hollowed out in practice. The restrictions were amounted to a closure of the courtroom imposed without the findings the law requires. Defendant does not contend that live streaming is constitutionally required in every case. The issue is that once physical seating was foreseeably inadequate, the court was required to consider reasonable alternatives and make Waller findings before excluding the public. Okay? The openness of criminal trials is among the oldest and most settled feature in Anglo-American justice. The United States Supreme Court has held that the public and the press possess a right secured by the First and 14th Amendment to attend criminal trials, and that absent an overriding interest articulated in findings, a criminal trial must be open to the public. A presumption of openness herein in the very nature of the criminal trial under our system of justice, for a public trial gives assurance that proceedings are conducted fairly, discourages perjury. Perjury. I don't know why the hell I said perjury. Excuse me. It's 1:21 a.m. Okay. Okay. It's 1:21 a.m. and we've been on here for 2.5 hours, and I already did 2.5 hour whatever live previous to this. But it discourages perjury and misconduct and guards against decisions based on secret bias or partiality. As the court observed, it would be difficult to single out any aspect of government or of higher concern and importance to the people that in the manner in which the criminal trials are conducted. Texas has long spoken to the same effect in its own voice. The Code of Criminal Procedure commands that the proceedings and trials in all courts shall be public. The Court of Criminal Appeals has embraced the presumption of openness recognized in Richmond newspaper, explaining more than a century ago that the Texas Constitution is but in accord with the genius and spirit of our free institution, which is intended to guarantee public publicity to the proceedings of our courts. These guarantees are not abstractions, and they are not held by the accused alone. The open trial guarantee belongs as well to the citizens of Texas in whose names the prosecution is brought, by whose taxes the courthouse and the courts are sustained, and whose confidence in the administration of justice depends on their ability to see that justice done. Public attendance is the mechanism by which the community observes that the courts it funds are functioning lawfully. A check on official power that the Supreme Court has repeatedly identified as a core purpose of the open trial guarantee. When the public is excluded from a Texas courtroom without lawful justification, the injury falls on the defendant, whose Sixth Amendment right is violated, and on the community, whose courtroom it is. It is the defendant's injury that this motion vindicates. The community's stake underscores why the violation is neither technical nor trivial. A public trial is staged for two audiences at once. The first sits in the gallery, the citizens in whose names the case is brought, who watch to satisfy themselves that the state proves what it claims, and that the accused is not quietly condemned. The second sits on the bench and in the jury box. The judge and the jurors, for whom the awareness of being watched is itself a discipline, keeping them keenly alive to the sense of their responsibility and the importance of their function. A 10-minute entry window empties both galleries at once. It turns the public away before it can watch, and it rivals the court of the very audience whose presence is the discipline. What the order describes as access operated in practice as material exclusion. History explains why the law guards the open courtroom so jealously. The public trial guarantee is a long-standing safeguard against secret proceedings. It has always been recognized as a safeguard against any attempt to employ our courts as instruments. What openness protects, secrecy endangers. A proceeding the public cannot watch is one in which the ordinary checks in error, overreach, and bias quietly fall away. That is the structural risk a closed courtroom creates. Whether or not anyone can later prove the harm, the secrecy concealed, which is precisely why the law treats the deprivation as structural and not put the defendant to proof of a hidden jury. So basically what they're saying is he's violating Karmelo Anthony's Sixth Amendment right for him to have basically a fair trial, right? And that Texas holds a rule about them having public courts, and that the judge, he ain't follow none of these rules. Girl, until we get them official court transcripts, if you ask me, they didn't prove murder. They railroaded him. Thank you. Okay. I was trying to see something. All right. The most directly applicable appellate authority on this precise question is a public decision of the Courts of Appeals, handed down months before the trial began. In Stricker versus State, the Fifth Court of Appeals held that a trial court violated defendant's Sixth Amendment right to a public trial and ordered a new trial. Wait a minute, hold on one second, because I don't want to sound like a dumbass. Hold on. Oh, I can't look it up. Hold on. So, your Sixth Amendment right guarantees the rights of criminal defendants in federal and state prosecution. It ensures the right to a speedy and public trial by an impartial jury, the right to confront and subpoena witnesses, and the right to legal counsel. So I just want to make sure that we understand what the Sixth Amendment is, okay? So his rights were violated. If you ask me, his Sixth Amendment right was violated by not giving him the public trial. They were violated because he didn't have an impartial jury. Okay? Their right to subpoena witnesses was stifled because of this gentleman's agreement that they had. All right? That's my public opinion. I think it was violated 3 times over. Okay, so in Stricker versus State, for the Sixth Amendment right to a public trial and order a new trial, where the court, citing courtroom space and a generalized security concern, refused to seat a single member of the public during jury selection without first considering the reasonable alternatives of the law. Because Stricker was designated for publication under Texas Rule of Appellate Procedure 47.2b, it is a published memorandum option of this Court of Appeals, and thus the most directly applicable appellate authority in the public trial question. And having been issued months before this trial, it was available for the trial court's review when the court re-entered an amended order and closed these proceedings. The closure here was therefore not the resolution of an unsettled question. It ran headlong into a recent published decision of the very court that reviewed this one. Every justification of the Fifth Court rejected the Stricker is a justification the court invoked here. And that rejection was on far more extensive facts. There, the court refused to seat one observer because of the veneer filed in the gallery. Here, I don't know. Here, the court rationed the general public to roughly 24 rotating seats across every stage of a nationally watched murder trial. There, the trial court declined to split Voltaire to make room, explaining, "I'm not going to spend 2 days picking a jury." The Fifth Court held that space and overcrowding, though legitimate concerns, must not outweigh the defendant's Sixth Amendment rights, because there are readily available alternatives, and that neither convince nor judicial economy could constitute an overriding interest. Here, the record and the court's own public statements at least raise a fact issue that reasonable alternatives exist, including larger and additional courtroom space and live audio and video feed, and the overflow accommodation the court used during the jury selection and then withdrew. And where the Stricker court faulted the trial judge for failing to identify a specific concrete fact of danger, the order here rests on the same generic recital that unrestricted access may compromise security, entered without a hearing. If excluding a single member of the public from jury selection required a new trial in Stricker, then the reoccurring exclusion of numerous members of the public from testimony and punishment after the court withdrew an available overflow alternative and made no Waller finding cannot be dismissed as trivial. So basically, in this Stricker case, they had a similar situation, but it was rectified. So they're saying that this judge has absolutely no right, no rhyme, or no reason to keep people out. Now, they're going to continue talking about this, I can see, for a little while, okay? And his Sixth Amendment right. They're still talking about it here. Before a trial, court may exclude the public from any part of a criminal proceeding and must satisfy a 4-part test of Waller versus Georgia. Okay, number one, in order for him to be able to reject the public, he has to, number one, prove that the party seeking to limit access must advance an overriding interest that is likely to be prejudiced. Number two, any limitation must be no broader than necessary to protect the interest. Number three, the trial court must consider reasonable alternatives to closing the proceeding. And four, the trial court must make findings adequate to support the limitation. The Court of Criminal Appeals has adopted and apply this test. The trial court bears the burden of considering reasonable alternatives. The balance of interest must be struck with special care, and findings by trial court and linchpin of the Waller test. So again, they're going on about how it was violated. They violated by not allowing the public in. Okay. 10 minutes a day did not keep this courtroom open to the public. A reviewing court first categorized the restriction. A full closure is tested under all four Waller factors. A partial closure is tested under the same factors that the first, requiring a substantial rather than an overriding reason. Okay, so we're still talking about the courtroom. Defendant bears the initial burden to show that the trial was closed to the public, but that burden is carried on the totality of evidence and so they're still talking about that. Those declarations excluded members of the public who came across the country to attend. The reviewing court instead asked whether the trial court fulfilled its obligation to take every reasonable measure to accommodate public attendance. Here, the cumulative effect of the 9 media cap and the 10-minute public entry window, space available seating, and the no re-entry rule, and the absence of any overflow or live stream establishes that members of the public were excluded. The defendant has carried his burden to show that the proceedings were closed. These facts are further established by the accompanying declarations of members of the public who sought to attend the trial and were denied entry into the courtroom. Those declarations executed by members of the public who came from across the country to attend established the closure concretely and consistently, and no witness observed any disturbance or security incident that would explain it. Jacqueline Yan traveled from North Carolina on the first day of testimony. She found a line of roughly 80 to 100 people and watched as only about 27 were admitted, with no overflow room provided for the remainder. Tierra Allen flew from Arizona to observe jury selection from an auxiliary viewing location she knew as the Oval Room. On June 1st, 3rd, and 3rd, she viewed it from the Oval Room on June 1st and 3rd. On June 4th, she was told that accommodations had been limited and she was excluded from the courtroom on both June 4th and 5th. Bridget Smith attended on June 1st, 4th, 5th, and 6th and confirms that public seating was capped at roughly 27 seats. That admission was divided into 2 lines, one for the media list and one for everyone else, and that the outside viewing location used during jury selection was eliminated once testimony began. Tamitra Carter arrived before dawn, and though identified as number 7 on an early arrival list, was removed from the June 5th line and lost the morning proceedings because only about 27 public seats were available. Kiera West, a member of general public with no media affiliation, was denied entry on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. And Tony Toussaint, the defendant the defendant's own grandmother, attests that family access was capped at 8 seats in total. So the defendant's grandfather and aunts were excluded from his trial altogether, and that even those admitted were required to register a day in advance and were warned that a visible facial expression could result in removal. One member of the public attended the trial nearly in its entirety and provides a day-by-day account of that corroborates each of these features from inside. Nakia Washington traveled from Cincinnati, Ohio, and was present at the courthouse on June 1st, 3rd, 4th, 5th, 6th, 8th, and 9th. During jury selection, the court used an auxiliary viewing room, the memorial room, that seated roughly 60 members of the public and carried a live video and audio feed of the proceeding. On June 4th, the first day of testimony, the public was informed only after arriving that the overflow would not be available for the remainder of the trial, and access thereafter confined to approximately 27 seats in the courtroom, with no overflow room, audio feed, or video feed of any kind. Access each day was governed not by the order's admission but by a pre-dawn line that formed as early as 4 and 4:30 a.m. was counted off in groups of 27 and was inconsistent at times chaotic. And although Miss Washington ultimately gained entry on each day she attended, she was excluded from the morning proceeding on both June 4th and 5th, admitted only in the early afternoon, after substantial portions of the day had already passed, so that even an attending member of the public was denied access to significant parts of the trial. She observed no disturbance, no disruptive conduct inside the courthouse that would justify excluding the public. The only altercation she witnessed occurred outside in the line and arose from the very manner in which the court administered access. Looking a certain way with facial expressions. Yes, that's what they told them. Thought they said you couldn't be there before 6. That's what they said. But members of the Metcalf family and Sarah Fields, who was hobnobbing with them because she's in good with them, they were on that line early. This case is not controlled by decisions in which the state may rely. In Dixon versus State, the Court of Criminal Appeals held that the public trial right is forfeitable, and that the full courtroom standing alone does not violate the guarantee, because the right does not require the court to seat every person who wishes to attend. Defendant does not contend otherwise. The violation here is not that the courtroom filled. It is that the courtroom adopted in advance and without case-specific findings a reoccurring access regimen that limited the general public to a 10-minute daily reentry window and roughly 24 seats, barred meaningful mid-proceeding access, and furnished no contemporaneous alternative for those foreseeably excluded. Nor would Dixon's deposition aid the state. The claim exclusion was a portion of a single day's closing arguments provided by one witness against the other witness, against an otherwise silent road, and the trial court resolved the resulting factual dispute only after a contested hearing. Here, the closure spans the testimonial phase after the trial and is established by 7 mutual corroborating sworn accounts. By the written admission of the court's own appointed officer that there is no overflow room, by the court's own televised confirmation of the seating figures, and by the undisputed elimination of an accommodation the court has itself been providing, and no findings of any kind exist to which defense would attach. Okay, so they're still going about public access. It ain't never gonna stop until we start fighting back. I'm not talking about marching neither. I hear you. Defendant look, Sherm, there goes swag. Defendant need not prove that every seat was empty. Okay, we're still talking about that. So they gave us this, which was the seating. I thought we saw this already. Did we somehow go backwards? Okay, they're talking about overflow rooms again. I think Henny Glass is in the chat. If you've heard enough about the public not being in there and, excluding cameras and audio and because is it me or does it sound like they just repeating themselves over and over again? Somehow I knew you were going to put a glass, Kristen. Uniquely. King CJ said, okay, can we just, skip a little bit? Okay, he's still talking about it because remember, they're talking about the Waller test. They're trying to drive the point home, guys. Yeah, they are. But we get it. We get it. Okay. Okay, so they're still talking about that on here. Okay, let's get to this part right here. Finally, the order applied the wrong constitutional standard. It characterized restrictions as reasonable time, place, and manner restrictions. The standard that governs the regulation of speech in public forum. That is not standard for excluding the public from criminal trial. Reasonable measures that merely administer the courtroom may be permissible, but the provisions that exclude the public, the 10-minute window, space availability, sitting behind the media cap, and no reentry rule, and the absence of any overflow affect a closure governed by Waller and Press Enterprise, not by the more lenient time, place, manner test, by treating an access closure as a time, place, manner regulation. The court applied a less demanding standard and bypassed the findings Waller required. The order's reliance on Shepard versus Maxwell does not exist. Shepard's concerns a court duty to control prejudicial publicity and press conduct to protect a fair trial. It does not authorize excluding the public from the court. Okay, so they said, and finally, so we should be done. No, because they're mentioning Waller again. A standing order is no substitute for an open courtroom, and every reasonable alternative was ignored. So we know they ignored the reasonable alternatives. They're still speaking on restricting access, and they're citing other cases. So this is not really for us. This is more for the trial courts, the appellate courts to go look into these cases and for them to actually go over them and see how they don't line up. Okay? I want to get to the good stuff. I want to get to, okay, we know about the 15 family seat allotment, and the Karmelo Anthony's family was only allotted 8. Okay, and they were supposed to have 15, and they had family that traveled from Baton Rouge to come. All right. The court's off the record sealing of the record was unlawful and harmful to the defendant. Okay, let's get it. The secret did not end at the courtroom door. It reached the court record itself. Beyond a gag order that silenced the parties, counsel, and witnesses, the court directed that motions and subpoenas be hand-delivered to the court and held under sealed. And the court, not the district clerk, served as a custodian of the case file, which was kept in chambers rather than in the district court's public file. No public order authorizing the arrangement, supported by notice, hearing, and findings, the law requires before a record may be sealed, was ever entered. So they never even filed the proper paperwork that's required by law to seal these records. The docket nonetheless reflects a series of orders restricting the record in order to redact. an order to redact, and an order to seal. So they did the order to redact on June 25th. Remember, I told y'all that they were redacting stuff. They were trying to hide something. Remember, I said they're trying to hide something. They're redacting stuff. Then there was an order to redact and an order to seal, both on June 11th, and further ordered on June 18th that the public docket leaves undescribed. The filings in a high-profile prosecution were thus unavailable for contemptuous public inspection in the ordinary course. Basically, we were supposed to have been had these records, like we've been telling y'all. We were supposed to have been had these records, and we didn't get them. We didn't get them. We didn't get them. Okay, I can't do that. Okay, so the sealing was not confined to particular files. The entire court file was placed under seal by oral order, with no written order, no public notice, no open hearing, no findings to justify holding the records from public view. The breadth and basis of that order are confirmed by the court's own statements. At a conference held on June 29, 2026, the court advised the parties that the entire court file had been sealed by oral order and that counsel cannot access the file unless he first agreed not to disclose what he observed in it. Counsel responded that he could not commit to withholding information he had not yet seen, and the court left the file unavailable for inspection only in the court's chambers. The episode lays bare the character of the closure. Access to the record of a public criminal trial was conditioned on a promise of secrecy. Why y'all still trying to keep this case a secret? It had already came out. Whatever it was that you were trying to hold back, we already know now. We know about the gentleman's deal. We know about all of that. We know about all of it. Okay? There's no need at all. Man, listen. And now you can only view it in the judge's chambers. And he's saying if you can't keep your mouth shut, you can't see it. Okay? The episode lays bare of character of the closure. Access to the record of public criminal trial was conditioned on a promise of secrecy that no responsible advocate could give. And the file was kept quiet, literally, in the judge's chambers, beyond the reach of the public and the defense alike. An oral order sealing an entire court file, pronounced without notice, hearing, or finding, is sealing in its least reviewable form. There is no order to contest, no findings to test, and no record of the decision to seal it at all. This continuing denial of access to the file is of a piece with the closure of the courtroom itself. Both withhold the open proceeding. The Constitution guarantees, and both confirm that the secrecy was structural rather than incidental. Okay? You can't tell me his lawyer wasn't involved, because why would any lawyer want to win because why would any lawyer that wants to win ever agree to that useless? Their client has some crazy degenerate or something. Right. Karmelo's not any of those things. It's more that will come out with new attorneys. Didn't put everything out yet. they put out enough. I don't know what else they could possibly give us. They've already blown this case out the water. Conditioning counsel's access to the file also impaired defendants' ability to investigate and present this motion within Rule 21's short deadline. Counsel could not reasonably agree not to disclose or use information before seeing it. The condition therefore prevented counsel from inspecting the complete file during the very period in which counsel was required to identify, verify, and present extra record grounds for a new trial. Defendant does not ask the court to decide the public's independent access rights in the abstract. He relies on the file restriction because it affected his own ability to litigate this motion, and because it corroborates the same off-record restriction of public access that occurred in the courtroom. So think about this. Think about this. The day following the trial, the motion for the appeal goes in. The judge knows that the appeal is going in. The judge restricts all information in hopes that these trial attorneys or whatever trial attorney is not going to have time, won't use resources to obtain information so that they can go ahead and proceed with this appeal, in the hopes that they'll miss their deadline and he won't get this appeal. That is what Judge Roach is holding those files for, to try to screw over Karmelo's appeal. Excuse me. The public and the press hold a constitutional right of access to criminal proceedings and to the records of those proceedings, and the court may not seal the record of judicial proceedings in secret. That right of access is a fundamental element of rule of law, and court's discretion to seal is to be exercised charily. I don't know what that means, but okay. Only after it identifies the balance of competing interests in the record. Sealing without public notice and the opportunity to be heard is itself unconstitutional. A court may not maintain a file or docket that hides filings from view. This is why they want his ass up off of this damn bitch. Out of this case, I mean. He leaving in 6 months. But yeah. In Texas, the right to access is both constitutional and statutory. The open court's guarantee of the Texas Constitution and the Command of Code of Criminal Procedure that the proceedings and the trial in all courts shall be public, secure the public's access to criminal proceedings and to the records generated in them. All right. The records of a criminal case are therefore presumptively open, and a court may not seal or sequester them without public notice and open an open hearing and a specific finding. Although Rule 76A governs civil court records, the same principle of public access applies with full force in criminal proceedings, and defendant relies on criminal open court guarantees, not Rule 76A, as the governing law. Okay? The court honored none of these requirements. It sealed and sequestered the records without a public motion, without notice, without an open hearing, without findings sufficient to justify withholding the file from the public. Take one at a time. Each of these measures might be debated. Taken together, they accomplish what the law forbids by any route: a proceeding materially closed in operation. The general public was rationed to 10 minutes entry window and rotated and rotating a handful of seats. The press was capped and the remaining public turned away. The overflow feed was switched off once the testimony began. Substantive pretrial hearing went unrecorded. A gag order restricted the covered persons who might have described what was happening, and the case file itself was drawn into chambers and sealed by oral command without notice, hearing, and finding. The through line is not any single rule, but a consent effort. Public access was materially restricted through written limitations, off-record admissions, and record sequestration. That is the structural injury the public trial guarantee exists to present. A proceeding conducted under these conditions is not an open trial marred by isolated irregularities. It is a proceeding materially closed in operation, and the deprivation is complete the moment the members of the public are excluded without Waller findings, regardless of whether the outcome would have been different. The record sequestration did more than offend the public's right of access. It directly harmed the defendant. The period after the judgment was marked by a rapid succession of counsel. On June 10, 2026, trial counsel withdrew and the court appointed appellate counsel, who was then replaced by newly appointed appellate counsel before the defendant's present counsel were substituted in on June 23, 2026. Throughout that period, and while the 30-day deadline for the motion for a new trial was running, the material necessary to evaluate and prepare the motion was held by the court in chambers and were absent from the public file. Each successive counsel was thus required to come up to speed and to prepare against a hard statutory deadline on an incomplete, inaccurate record. The court's record could not fill the gap. When counsel contacted the official court reporter, counsel was advised that no portion of the trial had been transcribed. Counsel was thus left to prepare this motion with neither the pleadings and case file held in the court's chambers, nor any transcript of proceeding. The public docket, for instance, reflects no motions in, I forgot how to say that word, lemonine, whatever, and would suggest to any reader that no substantive pretrial litigation occurred. An impression and sequestration of the file left no fair opportunity to test in time allowed. By withholding the record during the very window in which the defendant and his changing counsel had to identify and develop grounds for relief, the court's unlawful sealing compressed the defendant's effective time and deprived him of the complete and accurate record to which he was entitled. The defendant's entitlement to a new trial rests on his own Sixth Amendment right to a public trial. The court's off-record sealing confirms that public access was materially restricted in both the courtroom and the case file, and the restriction was structural rather than incidental, and by impairing the defendant's ability to prepare his motion on a complete record, it worked a distinct unfairness that reinforced the need for relief. This resulting violation is structural. The defendant does not seek in this motion to litigate the public's or the witness's independent speech rights in the abstract. Defendant relies on the gag order because, together with the access restrictions and the record sequestering, it limited contemporaneous public understanding of the proceedings and underscores why the denial of public access was not harmless, trivial, or curable after the verdict. The physical closure did not operate alone. From July 28, 2025 through the verdict, every person with firsthand knowledge of this case, the parties, their attorneys, the witnesses, expert consultations, agent, spokespersons, law enforcement, and court staff was forbidden on pain of contempt. from making any statement that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness, or that intends or is likely to influence public opinion, potential jurors. A prior restraint of that Bredrith, I believe is what you said. I don't know. She said lemon line. This is why I don't stop in small towns when I'm traveling. Listen. It's presumptively unconstitutional under Article 1, Section 8 of the Texas Constitution, which provides greater rights of free expression than its federal equivalent. It is, and it survives only upon specific findings supported by evidence that one, an imminent and irreparable harm to the judicial process will deprive litigations of just results of their dispute, and two, the judicial action represents the least restrictive means to prevent that harm. On July 28th, orders apple juice. On July 28th, orders finding failed that test on their face. A finding that media coverage has the potential to cause imminent and irreparable harm is a finding of possibility, not imminence. The speculation Davenport forbids. No evidence is recited, none was heard, and the finding that the venue change, juror screening, and sequestration would be inadequate alone concedes the point that decides the issue. The alternatives exist, and the court knew them by name. Indeed, it went on to employ two of them. Screening. Okay, listen. They're driving their points home at this point, and I'm trying to see if there is a new point that they are trying to make. Hold on a second. I'm sorry. Where were we? Yeah, the restraint interlocked with the rest of the design, the gag orders. Okay. The gag orders, sole safe harbor, procedural announcement, hearing schedules, court filings, presupposed a public docket. The court then sealed the finding by oral. Okay, we know. All right, they're talking about the Waller again. They're talking about the closed courtroom. Okay, let's just. Okay, listen, I think we've gotten the majority of this because this is, we do have a couple more. I want to hear the conclusion of what they have to say. Okay. Finally, the alternative, the court should grant a new trial on the interest of justice, because they've really gone into a lot of different things. So maybe we should go into their third. It is getting late, and I could always go back over this another day. I think we get the gist of why they're asking for a new trial. What do you say, guys? Finally, and in the alternative, the court should grant a new trial in the interest of justice, even where no single ground independently sufficient the collective of them. A trial in which public access was materially restricted during the testimony phase, a mid-trial redo, I don't know, of the parties' agreement. Okay, so they went basically like a reneging of the parties' agreement that coerced the defendant's silence and gutted his self-defense presentation, and an unsupported instruction that narrowed the same defense, deprived the defendant of a fair, open, and adversarial trial that constitutions guarantee. The court retains discretion to grant a new trial in the interest of justice where a valid legal basis supports it, okay, and the grounds above supply the basis. Wherefore, premises considered, the court restricted the general public to a 10-minute daily admission window and provided no contemporaneous alternative for those foreseeably taken away without the findings Waller requires. The resulting closure is structural error that a new trial is required to cure. Defendant Karmelo Anthony therefore respectfully prays that the court sets this motion for an evidentiary hearing, at which the facts concerning the closure of the courtroom, the delegation of the courtroom access determination to a non-judicial officer, the parties' unrecorded agreement limiting character evidence and its reputation, and the preservation and harm facts concerning the unsupported provocation, instruction may be developed. Grant the motion, set aside the judgment of conviction and sentence, order a new trial, conduct in the courtroom open to the public, enter written findings of fact and conclusions of law in support of its ruling. Grant the relief requested in the interest of justice, and grant such other the further relief to the defendant may be justly entitled. Respectfully, Russell Wilson. Russell Wilson, you sound like you are the bomb.com as a lawyer, but goddamn, you are long-winded. Okay? Okay. And so it starts to get into the exhibits. So let's just see. I don't remember how many exhibits it is, but I will probably take the time to go through the exhibits. Okay, so this is a whole transcript. I mean, Colin County should be a model for high profile. Okay, yeah, that's the transcript from then. We could probably go through these transcripts at a later date. Well, not a later date, but we could probably like break these down. Oh my goodness. Well, I did say it was 100 and something pages. It's 100 and something pages. And I could reread a lot of this stuff that we've already read. Look at this. I'm still going. This is all evidence. You think I was going to sit here and read all of this evidence tonight? Child. Okay. Yeah, we could go through this evidence piece by piece. We can go through this evidence piece by piece as the days unfold. I'll probably just do videos on them or something, and I'll definitely be posting them to my Instagram, so make sure y'all are following me. Whoo, child, this was a long one. This was definitely a long one, but I am definitely not mad that I read it. So here's the takeaways from this for me. Karmelo was definitely railroaded. Karmelo deserves a new trial. There's no way to get around it. There's no way to get around it. He deserves a new trial. Because at the end of the day, oh, let me take this down. Stop sharing this screen. Let me make myself. We all knew that there was some felonious bullshit that was going on. We knew it. We all freaking knew it. Put myself back like this. Migo, go to bed. You are in trouble still. I'm not done being mad at you. But it's one thing to think something. It's another thing for you to actually like read it in the court filings. It's another thing for us to see it all play out on paper and to actually hear how he was railroaded is completely diabolical. There's no getting around that. There's no excuse. There's no explanation. There's no nothing for that. If I'm being honest. I would have, even in my wildest dreams, I would have never thought that the railroading would have been this bad. I don't know what I would have, I don't know what I expected. I just didn't expect this. They robbed this boy of his life, of any opportunity for a life. This judge is a piece of shit. He's a piece of shit. Let me see what y'all over here saying. They really, okay. I knew it was time to go when they kept calling me city boy. Oh, Lord. Child, your throat gonna be sore if you read all that. Pause. I not only want him free, I want them assholes arrested. Same. Big Rage! Where you been? Oh, man, where you been? We ain't seen you in forever. It's great to see you. Throw them racist motherfuckers in prison with the same people they hate for no reason. Here's the thing. I feel like this judge, the prosecution, first of all, the prosecutor is already a piece of shit, and we knew that because Dr. Candace Matthews exposed him for having a federal complaint against him, a federal case about sexual harassment. Oh, and you know what? For those of y'all who stuck around, I got a little treat for y'all. Let me give y'all a little something. I think I have it. What did I do with it? I wonder. Oh, did I download it? Please, Henny, say you downloaded it. Maybe I still have the window open on my phone. Don't judge me because I'm one of those people that will have like 5011. Oh, no, I got to give y'all an update on that for y'all try to come for me. Because if y'all hear someplace else, y'all don't be mad at me. Oh, this is the Lingham guy. No, it was something on him. Did I save it? Oh, man. I didn't save it. Oh, I'm going to be so mad at myself if I didn't save it. Hold on, y'all. Let me look. Is this it? I think this is it, y'all. This is it. What? Little genie falling from the sky. Let's get rich. What? Is this it? Yes, it is. This is it, boy. I love it when a plan comes together. So, as if I have not read enough, let me see if I can get a brief summary of this really quickly. I love it when a plan comes together. Okay, well, since you want to be an asshole, I could just do this because that's how I found it. And then do that. All right, so let me get y'all a brief little synopsis of the court document because I've already been reading, right? So, I have a judicial conduct opinion regarding Judge John Roach. Dun, dun, dun. It's a little lengthy, but since we're all here and we're all wide awake, we might as well. Anybody who falls asleep, they'll have to catch it in the morning. Put myself back over here. Put this up here. Hold on, what do you mean? Oh, I know why. Dun, dun, dun. Okay. So, this, my dear, is paperwork on one Judge John Roach. And this is a special court of review in regards to an inquiry concerning the Honorable John Roach Jr. The Special Court of Review has considered the pleadings, the evidence, and the arguments of counsel and finds that the Honorable John Roach Jr. willfully violated canons 2B and 4D1 of the Code of Judicial Conduct and Article V, Section 1-A6A of the Texas Constitution as alleged in charges 1 and 2 by leading the prestige of his office and exploiting his position as a judge to further the private interest of himself and his wife. Shall I proceed? Did I wake y'all up with that one? Nah, y'all don't want to hear this. Y'all don't want to hear this. Y'all don't want to hear this, right? Y'all ready to go to bed. Y'all want to go to bed. Y'all want to go to sleep. I know. We could, we can go to bed. All I see is yes, indeed. The appropriate sanction for this conduct is a public abomination. The Special Court of Review finds that the Honorable Judge Roach Jr. It finds Honorable Judge Roach Jr. not guilty insofar as charges 2 alleges that he engaged in activities involving himself in frequent transactions with persons likely to come before this court. The court finds that Honorable John Roach Jr. not guilty of violating Article V. Okay, let's get into it. This case addresses Judge John Roach's activities in connection with one, a law-related book discussing divorce litigations, which he co-wrote and published with his attorney wife. Two, a referral service run by his wife to connect potential clients with attorneys who focus on divorce-related matters. And three, a website for the referral service that offered the book for sale. The State Commission of Judicial Conduct received complaints in June of 2016 regarding these activities and notified Judge Roach in May of 2017. It subsequently convened an informal hearing and determined in February of 2018 that Judge Roach should not receive a public warning. Judge Roach requested a review of the commission's determination, and the Superior Court of Texas selected a court of review. The commission contends in charges 1 and 2 that Judge Roach's activities in connection with the book, the referral service, the website violates canons 2B and 4D1 of the Texas Code of Judicial Conduct. The content that Judge Roach violated these canons by leading a prestige of his office and exploiting his position as a judge to further the private interests of himself and his wife. It further contends that Judge Roach's activities involved him in frequent transactions with persons likely to come before his court. The commission contends in charge 3 that Judge Roach violated section 1A, 6A of Article 5 of the Texas Commission because statements in the book regarding the divorce process and judicial system cast discredit upon the judiciary, and because he actively encouraged people contemplating divorce to avoid court and purchase his book instead. The parties participated in a trial de novo on May 29, 2018, at which Judge Roach was the only witness. Having considered the parties' evidence and arguments, the Court of Reviews issued this timely decision. We conclude that Judge Roach willfully violated canons 2B and 4D1 of the Code of Judicial Conduct in Article 5, Section 1, the Texas Constitution, as alleged in charges 1 and 2, by lending the prestige of his office and exploiting his position as judge to further his private interests of himself and his wife. The inappropriate sanction for this conduct is public abomination. He's a public abomination. Okay? But they did find him not guilty of charges 2. Judge Roach has served as a prestigious judge in the 296th District Court of Collins County since 2007. His wife, Laura Roach, is an attorney who devotes about 80% of her practice to conduct mediations and family law cases. Together, they conceived and launched a multifaceted project aimed at spouses contemplating or seeking divorce. This project, which we refer to collectively as Divorce in Peace, had 3 interconnected components. 1, a book, 2, a referral service that allowed potential clients to identify and contact attorneys, and 3, a website, the book. Judge Roach and Laura Roach co-authored the 212-page book entitled Divorce in Peace. The book includes a subtitle on the front cover, Alternatives to War from a Judge and a Lawyer. It also includes 122 pages of appendices and a 15-page glossary of legal terms. Judge Roach testified that he wrote the book to promote the use of alternative dispute resolutions in divorce cases, not to make money. But you did. He also testified that he conducted legal research to determine the permissible limits of his actions as a sitting district judge in writing, publishing, and marketing a law-related book. He did not contact the commission, the State Bar of Texas, or persons that with expertise in judicial ethics as part of the research. So are we even surprised that he can't follow the ethics? Oh, he hasn't skedaddled yet. Chandrila. He has not skedaddled yet. He's still in office. Yeah, he retires, I guess now in the next 5 months. But he's still there. Yeah, he's still there. I know people are saying that he's gone, but he's not. He's not. The book's front cover lists John and Laura Roach as authors. The back cover features a photo of the authors together. Next to this statement, John and Laura have spent their careers as lawyers and a judge, trying to help couples avoid the pitfalls of high conflict divorce. If it wasn't for money, listed as a free ebook. And about the author section at the book's beginning describes John Roach as a Texas district court judge with a true passion for law and statutes, that as a judge, he has had a front row seat to over 10,000 family cases. So how many criminal cases? Okay. The book's text does not refer to Judge John Roach or Judge Roach. Among other things, the Divorce and Peace book describes how the family court system operates. It advises couples contemplating or seeking to divorce to consider using alternative dispute resolution as a more productive way to end your marriage and path to peaceful divorce. So did they take a path to peaceful divorce or not? That reduces the expense and emotional toll of divorce litigation. It describes how various alternative dispute resolution procedures operate in contrast to procedures used as part of divorce trial. Throughout the book, the section entitled Judge's Perspective and Mediator's Perspective offer additional comments on particular topics. Okay, I want to know. See, you're going to make me do a deep dive on Judge Roach. Okay, the client referral service of the website. So they were giving referrals to all of these. Which one of them is her? Divorce and Peace, I will say, accomplished through the for-profit. Okay, helping couples for like-minded professionals was accomplished through a for-profit entity called Divorce and Peace LLC, which we refer to as DIP LLC. Laura Roach is DIP LLC's registered agent, only member and designated managing member. Judge Roach is not a member of the IDP LLC and disclaims any ownership of the LLC. He testified that Laura Roach spent approximately $50,000 in community assets to create and launch DIP LLC. All right, so hold on. I need a summary for y'all because now my eyes are starting to get tired. They're starting to blur a bit. All right. So basically the problem is that the court found that Judge Roach didn't write the book. He actively helped market the entire business, and he was using his judge status to do so. So basically what it says is the book repeatedly directed the readers to the website, and because it was also referring them to these law services, it was a problem. Now, the canon to be was by leading the prestige of his judicial office. So we've already read that part. The judge said the issue wasn't that he wrote the book. The judges are allowed to write books and speak about them. But the problem was that the book was intertwined with a business that marketed attorneys and generated revenue. This was not like a free book. Like you were saying, he should have just marketed it as a free book if it was not for profit, but it was. So the courts ruled, they actually rejected the claim that he inappropriately engaged in frequent business transactions with lawyers likely to appear in his courtroom. And they rejected the allegation that statements in his book criticized divorce litigation. So what did they find him guilty of, right? Because that's what we want to know. What did they find him guilty of? And I honestly feel like it was his conduct. Like, that conduct speaks volumes to me. Thank you. So the canon 2B, which was using the prestige for private gain, the court found that Judge Roach inappropriately used the fact that he was a judge to help promote the private business venture and benefited for himself and his wife because he co-authored this book with her. The book, like I said, directed readers to a website. The website promoted paid attorney referral networks. The marketing materials emphasized that he was a district judge, and he appeared in promotional videos discussing his expertise as a judge to market the project. So the court said that crossed the ethical line because he was using his prestige of being a judge to promote the book. The Canon 4D1, improper business dealings, they found that he engaged in business activities that exploited his judicial position. Even though his wife was technically the owner of this LLC, he still was engaging in business activities that financially benefited their household because they lived together. So by helping to promote it while serving as a judge, he violated the rule against judges using their office for advanced business interests. But they didn't find him guilty of frequently doing business with lawyers likely to appear before him or bringing, discrediting, any of the divorce attorneys. But like I said, they set it up here. A public abomination. Period. Not the judge needs a DP. Good night, T. Basically, he's unethical all the way around the board. There's nothing ethical about him. He's a violator. In every sense of the word. Found to be unethical. It wasn't really like no big kapow. But I thought that y'all would find that very interesting. Anyway, that's going to do. Oh, y'all saw that? Y'all can see that? Y'all don't need to see that. Don't save. All right. That's going to do it for this. I mean, we've had our muffin cats. Yeah, I'm tired. We've had our muffin caps blown black. I can't talk. We've been through a lot tonight. We've been through a lot tonight with each other. It's been a wonderful almost 4 hours that I have spent with y'all. I wasn't going to do this tonight, but I'm glad that I did. But just know that y'all ain't getting no spiked coffee in the morning because I'm going to be asleep. All right. So by the time I get up, it'll be probably time to do Wicked Wednesday, and then it'll be time for the rush hour. Rush hour rounds for everybody. Okay. But I love you guys. Thank you so much for supporting. I don't know which channel you were on because we were streaming from 3 platforms or 2, 3. We were streaming to 3 platforms: YouTube, Twitch, and Kick. I don't know where you are, what you watched, how you watched it, but I'm glad that you did. Thank you so much. I appreciate y'all. I will see y'all in the morning. So when y'all rest well. Good night, everybody.